As chair of the House Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with House Rule 67 and the governor's emergency order number 12 pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing of bills referred to the Judiciary Committee. Executive session on pending legislation may be held. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting complies with House rules and RSA 91A, the right to know law. Anyone who has a problem accessing the meeting should call 271-3600. That's 271-3600, or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. We do have one staff person who will be monitoring the meeting. That's Jennifer Four, our committee researcher. Please note that all votes that are taken during the meeting shall be done by roll call vote. We'll begin the meeting today by taking roll call attendance. When each member states their presence, please also state whether there's anyone in the room with you during the meeting, which is required under the right to know law. I'll begin by saying, I'm Ned Gordon. I'm here at the Legislative Office building with two other committee members. Mr. Clerk, would you call the roll?
Representative McLean.
I'm present in the committee room at the LOB.
Representative Sylvia.
Home alone in Belmont.
Clerk is here. Representative Walker. Representative Alexander.
Good morning. I'm here in Goffstown. My roommates are in the house.
Representative Price. Representative Price. Representative Silver. Representative Green.
I'm here in my home in Hudson with my wife.
Representative Kelly.
I am home alone in Temple.
Representative Tosh. Representative Tosh. Representative Trotter.
Good morning. I'm here at my home in Belmont alone.
Representative Smith.
Good morning. I'm in Durham alone.
Representative Burt.
Good morning. I'm in West Milan, and other than Siri and Alexa, I'm alone.
Representative Oregon.
I'm here in Durham, and I don't even have a Siri or an Alexa, so I'm really alone.
Representative Lorenzo.
Good morning. I'm here in my home office in Newmarket, and I'm alone in the room.
Representative Chase.
And I'm here by myself.
Here one. Representative Chase, can you speak to us?
You hear me?
Yes, thank you.
Sorry, I'm here alone in Rollinsford.
Representative Kenny. Representative Langley.
Good morning. I'm here in Manchester and my husband is in the house.
Representative Macbeth. Representative Macbeth. Representative Page.
Good morning. I'm in Exeter. Children in the house.
Representative Simpson.
Good morning. I'm here in Exeter. I'm alone in the room now. My spouse and sons may pass through later in the day.
Very nice, thank you. So, roll, but
Okay, our first item of business today is House Bill 149 FN, an act extending certain civil immunity to public and private entities during major public health emergencies. The primary sponsor of this bill is Representative Stapleton. Representative Stapleton, would you like to introduce your bill?
Yes, thank you, Mr. Chair and members of the committee. For the record, my name is Walter Stapleton, and I represent Claremont Ward 3, Sullivan County, District 5. I bring you 149 FN House Bill, which affords a limited liability immunity to persons, entities, businesses of all sorts as defined in the bill when they act in good faith and in observance of recommended health care standards relative to national or state emergencies as declared by the governor or the legislature, and yet are being sued by persons who may have attracted COVID or other diseases. It is the burden of proof upon the person under this bill to prove that they have contracted the COVID or other related diseases by virtue of negligence, wanton disregard, or malicious or intentional misconduct of the business or entity. This bill came about from a constituent request. Business in Claremont that was worried about having detrimental and frivolous lawsuits levied against them after already having suffered a downturn of economic activity and difficulty under COVID. And I think that is maybe shared by many businesses that suffered a loss of reduction in business and yet are fearful that they may get another hit with a frivolous lawsuit by someone who has contracted COVID and then bring that lawsuit to the business for further trouble and harassment. So the bill is a protection against that type of frivolous lawsuit action. And what we did when we started this back in the summertime, we had legislative services look into what was going on in other states. And at the time, there were about 15 states that were already working on this, either by executive order, proclamation by governors, and followed up by statutes by the legislatures. Last night I did a quick abstract record of what was going on to date. And right now there are 48 states that have some action relative to this very subject. The District of Columbia, and only 3 states have taken no action for COVID immunity of liability. That would be Maine, Washington, and Texas. And of course, New Hampshire would be on that, except that we have this bill, HB 149, and the Senate also has come up with a similar bill, SB 63. Now, just briefly, my bill differs from SB 63 in that SB 63 is specific to COVID, whereas my bill is targeted for any health emergency declared by the New Hampshire legislature or the governor, similar to what we have now. And that way, we're not just limited to the current COVID situation, thinking that we may have more of these down the road in the future, either variations of COVID that we're being talked about now, and or some other new threat that we have to deal with on a state basis and or nationally. So I was trying to get the maximum mileage out of my bill by making it a little more applicable on a national emergency basis. Relative to the other states, there were about 19 of them that restricted their liability immunity to specifically COVID and specifically to healthcare facilities, workers, professions, volunteers, and so forth. The remainder are more encompassing, with the immunity extended to businesses, persons, entities, as well as healthcare professionals, businesses, facilities, and so forth. The common theme among all of them is the good faith principle, which we've adopted in this bill, that if a business person entity acts in good faith to observe the orders, statutes, directives of the state, the health department, CDC, the general guidelines of other applicable agencies, then they're afforded the presumption of limited liability and immunity to that. And this is not unlike what we already have in the statute at 508. We have about a dozen limited liability immunities. Not unlike one of my favorites is, for instance, the landowner presumption of immunity when they open up their land to public use for trail without fee, and they're immune from liability except if they do something that's untoward, unsafe, intentionally malicious, so on and so forth. 508:14.
Representative Stapleton, I want to cut you short, but we have a lot of people who have signed up to speak. So if you could kind of wrap up, it would be appreciated.
Yes, sir. And so I just wanted to draw attention to that we already have the liability immunities that can be challenged if there is other than faithful, good faith efforts to observe and keep the public safe at their establishment or at their premises. So with that, I'll conclude and leave time open for questions. Thank you.
Thank you for your testimony. Representative, first of all, before we do have some people with questions, but I just note to everybody that we have 10 people who have signed up to speak. And I see another hand up in addition to that. So I am going to limit the testimony at this point in time to for other speakers to 3 minutes going forward. And Representative Horgan, did you have a question for Representative Stapleton?
Oh, sure. Yes. Anytime through the court systems or anywhere else, when you provide a venue where people can seek, redress for damages or that some people are going to take advantage of, and that may not always be unfrivolous, but so I'm not sure. And there already of course are some protections for people who are filing frivolous lawsuits and or against people who aren't acting in good faith. So and of course I did notice that Texas was one of the states which doesn't do it, which of course is the state that recently lifted its mask mandate. So do you have any examples of any lawsuits, frivolous or not, that have in fact been filed for that that could potentially be affected by this law? I mean, are there any lawsuits here in New Hampshire or even elsewhere that you know of where they've been suing people because of COVID?
Thank you for the question, Representative Horgan. And that is a good question. I have to say, I'm sorry that I have not had time to investigate that. That would have been a logical follow-up prior to my coming here, but I have not been able to do that. So I'm not aware to what extent lawsuits have been filed in any of the 48 states and District of Columbia.
Representative Birch,
Very
do
much, Mr. Chair.
you have a question?
Thank you. And thank you, Representative, for taking my question. First of all, is it not true that we already have in the law provisions to take care of frivolous lawsuits?
Yes, I'm sure that we have more than adequate statutory authority for dealing with these things. But we felt that because of the special nature of the COVID pandemic and the possibility of lawsuits arising out of that might be frivolous, baseless, that we needed some protection. And I think it bears out that concern is valid by virtue of the 48 states that have enacted governor's proclamations, statutory emergency orders, and so forth. Yeah, it's not operating to the exclusion of those other statutes or orders, but in addition to.
If I could follow up with just a very quick question.
Go ahead.
Representative, you seem very numbers oriented. I'm wondering if you have the number of states that have passed legislation roughly equivalent to yours in terms of breadth of the legislation.
I use principally several of the states' language that came very similar to each other in the observance of some good faith efforts to comply with directives, executive orders, statutes, CDC directives, and so forth. But beyond that, it's all over the board with regard to who was covered. That's the major variance, is the entities that are covered in all of those 48 different states. But the common theme was that if people acted in good faith, without malice and without wanton disregard, that they would be afforded rebuttable immunity for their efforts. Does that answer your question?
Thank you. Representative Alexander, did you have a question?
Thank you, Mr. Chair. Thank you, Representative, for taking my question. My question is primarily around Section 1 of the bill, lines 10 through 16. I guess, so it says like there's an immunity for actual or alleged injury or infection or exposure resulting from a declared health emergency. But then it says the immunity shall not to apply in the case of willful negligence, wanton disregard, or malicious or intentional misconduct. There's an argument to be made that not wearing a mask, whether it is mandated by the governor or not, would qualify as a wanton disregard or a malicious or intentional misconduct. I guess I'm wondering, is there like an example of how this bill would further protect people like that, or would do something that isn't already covered in statute?
Well, thank you for the question. That is a good question, because with regard to masks, for instance, the jury seems to still be out in various circles of thought and even science. There are some, of course, that say that the mask can actually be harmful under circumstances. Others say it's mandatory to guard yourself and other people. The devil's in the details, but we could not address every possible recommendation or circumstance relative to PPE in the bill, and none of the states do that, that have enacted this type of legislation or executive orders. They've left it up basically to the states, the CDC, the health departments, those experts and scientists that can make the prescription best.
Okay, thank you.
Representative McLean?
Yeah, thank you. So we are pressed for time, so can you just give me a concise answer on this one? Because this is not a blanket immunity, because it's a qualified immunity of sorts, there has to be a violation of good faith. In practice, how would this work? Who would determine whether or not it was good faith without first going to court? So how would this work in practice?
I would suppose that a lawsuit is brought and it would have to appear to the court to make that judgment and the motion by attorneys to dismiss based on the statute, or to proceed based on the evidence that there was a lack of good faith, proper regard for the recommendations.
Thank you. Are there any other questions for Representative Stapleton? Seeing none, thank you for your testimony today.
Thank you.
The next speaker will be also a co-sponsor. That's Representative Baldessaro.
Thank you, Mr. Chairman. For the record, Representative Al Baldessaro, Rockingham County District 5, Londonderry. I'm here in an undisclosed location, and my wife is in the house. But anyways, I'm going to be real quick. This is a protection bill, and it's being proactive. We know it's on the books about frivolous lawsuits and other things, but the bottom line is it's costing businesses. It could cost business money right up front in lawyer fees. And then it's only, my understanding of the bill is only for the COVID, and protected. We already protect those pharmaceutical companies that are giving shots, vaccines to people. They have immunity. So why shouldn't we be proactive in protecting our businesses? And that's all I have. And I know you guys got a lot of work to do.
Thank you very much. Are there any questions for Representative Baldessaro? Seeing none, again, thank you for your testimony today.
Thank you.
Next speaker will be Israel Piedra, Representative Piedra.
Thank you, Mr. Chair. For the record, my name is Israel Piedra. I represent Hillsborough District 9, which is Manchester Ward 2, and I am speaking today in opposition to this bill. By way of disclosure, I am a practicing attorney, as many of you know. I represent both plaintiffs and defendants in a variety of litigation matters, including injury matters. There's a couple problems with this bill. The first being that it immunizes negligence, and that's kind of my biggest objection to it. And to the extent this committee continues to hear bills that attempt to protect for-profit businesses from the consequences of their own negligence, I will continue to testify in opposition to them. Simply put, this bill would allow negligent businesses, which negligently injure their customers, to avoid repercussions. Under current law, I think it's important to point out a business is only going to be legally liable if they are negligent. That's the current law. That's how the law of torts works. You're not liable. Someone gets COVID on your property. You're not liable just because one of your employees gives COVID to one of your customers. You're only liable if you were negligent and it is proved that you caused injury due to your negligence. So there's no statute that's necessary to protect a business from non-negligent behavior. I think it's important to point out that, to my knowledge and to my understanding to others' knowledges, that there have been no such lawsuits in New Hampshire relating to COVID injuries. I'm not aware of a single one. National organizations track this kind of thing, and they're not aware of any such lawsuit in New Hampshire. So really, this is a solution in search of a problem in that regard. I mean, the entire purpose of our justice system is that folks get to bring their claims into court and a jury of New Hampshire citizens decide whether that claim is valid. That's what's been done for hundreds of years. I think the second issue with the bill is its language and the structure of it. Frankly, it's very vague. It applies to uncertain things in the future, first of all. It also talks about willful negligence, which in my mind is kind of an oxymoron and not really a appropriate term for a bill. Negligence, as many of you know, is by definition something that's an accident. Willful, on the other hand, implies intent. So to the extent that the bill talks about willful negligence, it doesn't necessarily mean what you think it means. I believe it would be interpreted as someone intentionally injuring someone else due to COVID, or causing spread of COVID intentionally, essentially. So the language of the bill is, I think, too imprecise to really be workable. I think as a committee member pointed out, the language is also vague enough that whether a business actually complies in good faith or with government regulations is not actually something that is going to be decidable by a judge. That's a question that a jury is ultimately going to decide if there's any scintilla of evidence, in favor of the plaintiff. So to the extent that this bill is designed to prevent lawsuits from coming in the door, from going to a jury, it's not going to succeed, because ultimately, whether the language of the statute has been complied with is going to be a question for the jury. So in my opinion, just to conclude.
Yeah, if you could just wrap up, please.
I will wrap up. Yep, just in my opinion, to conclude, I think that this is a bill that seeks to have the legislature dictate who gets access to the courthouse. I think it's paternalistic, it's activist, it's unnecessary, most of all.
Okay.
So thank you very much for your time.
Thank you. Representative Sylvia, did you have a question for Representative Piedra?
Yes, thank you, Mr. Chairman. Thank you for taking my question. Just a brief one. With the spread of a virus like we have here, what are the chances you could possibly track down where you got it from as a lawyer bringing a suit? What's the difficulty involved there?
Thank you, Representative, for your question. I think that's a very important point. Thank you for bringing it up. And that you're precisely right. Being able to track where a COVID infection was incurred, I think, would be extremely and prohibitively difficult. And that's the exact reason why we haven't seen COVID-related lawsuits in New Hampshire, and we likely won't see them. It's because under a regular negligence claim, under the current law, you need to show that your injury was caused by the defendant. And part of that cause is showing that you contracted the infection more likely than not from that source. I think that's next to impossible to prove under current law, and another reason why we don't need this.
Thank you.
Thank you. Any other questions for Representative Piedra? Seeing none, thank you for your testimony today. The next person would be David Creer.
Hi, thank you for letting me speak today. My name is David Creer. I am Director of Public Policy for the Business and Industry Association of New Hampshire. We are very supportive of this bill, as well as the other ones that have been mentioned prior to this. So one of the top issues among our businesses is this safe harbor protections. They are afraid that while they're operating during the pandemic, they will face lawsuits from people claiming they've contracted COVID-19 at that business. And these cases, has already been implied, have growing to be very difficult to prove. And even if successful, well, that business still has to pay $30,000, $40,000, $50,000 to defend itself because everyone pays their own attorney fees for the most part in the U.S. So I want to say kind of a point that was made up. Even though these cases will be hard to win, even if winning, that business still has to pay that money while they're already struggling from the coronavirus pandemic. I also want to mention that this law would only apply to those businesses following state and federal guidelines for operating during the pandemic. So the issue that was brought up about immunizing negligence, well, if you're not following the state or federal guidelines, well, yeah, you can be sued and you should be, even in the eyes of, the BIA. We're not going to protect bad actors here. This is just people, businesses who are doing their best to help prevent the spread of COVID-19, just like everybody else. It's been asked how many have been filed. Over 200 lawsuits of this type have been filed across the country. None have been filed in New Hampshire yet, but there is a 3-year statute of limitations in New Hampshire, so it could happen at some point. And I also want to bring up that if there are never going to be lawsuits filed in the state, well, then passing the bill does no harm. There's no issue with doing it. Those lawsuits never would have been filed anyway. But if they would have been filed and could have put a business, this law could prevent businesses from having to pay these excessive legal fees and putting that business down permanently. I also want to address a couple issues. I think Representative Birch asked about frivolous lawsuits. The burden to meet frivolous lawsuit to get into those penalties is pretty high. And so what ends up happening is a person could sue a company for $20,000 claiming damages from COVID. But if it costs $30,000 to defend, well, the business has to pay. They're going to make that decision to just pay out the settlement. Well, then the next person comes and the next person. And it's really, this bill will help prevent that from ever occurring in the first place. And my last point here, I know we got short on time. It was asked about states and how many other states have passed similar laws. By my research, 19 other states have already passed similar legislation to this, and another 17 other than New Hampshire are currently considering those laws as well.
Thank you. Thank you for your testimony. Representative Horgan, did you have a question for Mr. Creer?
Well, yes. I noticed in the language in this bill, like in paragraph 2 of the part, it's intended to apply only to protect businesses, but it does also apply to individuals. So would you want to clarify the law to make sure that we're only protecting business, persons other than natural persons, that is businesses and other institutions, individuals, or are you happy with the language as is? Thank you.
Yeah, that's a great question. We're happy with the language as is. It's not just an issue. Obviously, I represent businesses, so that's where my testimony comes from. But this would affect, schools, places of worship, public parks, so the municipalities or any, building that they own that's open to the public. Really, any place where public can gather could see themselves facing these types of lawsuits.
Representative McLean?
Yeah, thank you, Mr. Chair. Just quickly, Mr. Creer, back to my earlier question, who makes the determination of good faith as to whether or not the case can go forward? That's a decision that has to be made, and it can't be made by the parties. So under this law, who makes that determination, and how would that happen?
It's a great question. I will preface this by saying that I am not a trial attorney. I've never done litigation, but my understanding would be that if that business is following all of the state and federal guidelines, then it's pretty clear that they were acting in good faith to follow them, because they were in fact following them. And that could be made by a judge in summary judgment. Now, if they were lacking in specific provisions, like they didn't require masks or something like that, then that would have to have a little bit more discovery in order to determine whether or not was acting in good faith. But I think, 99.9% of businesses are following all of the guidance. So it would be a pretty easy, clear determination that could be made by a judge.
Thank you.
Representative Horgan, did you have another question?
I'm good.
Thank you. Any other questions for Mr. Creer? Seeing none, thank you for your testimony today.
Great, thank you.
Next testimony would be, person to testify would be Bill Woodbury.
Good morning, Mr. Chair. Thank you for letting me speak today. Good morning, members of the committee. Can you hear me okay?
We can.
Thank you very much. So I wanted to first say that, first, my name is Bill Woodbury, and I am a practicing attorney in Laconia, New Hampshire. I also serve as legislative chair for the New Hampshire Association for Justice. I rise in opposition to this bill. I would like to indicate that I would echo the comments made by Representative Piedra I would incorporate them into my own in full. But given the limited time, I just want to kind of address, what Representative Stapleton and Representative Cryer have stated. I'm sorry, Mr. Cryer have represented here regarding that. Businesses are worried, and I think that this worry is fostered by this kind of this persistent specter of frivolous lawsuits that just doesn't bear out in the state of New Hampshire. As Mr. Cryer and Mr. Stapleton, I think, agreed, there have been no cases filed in the state of New Hampshire. And Mr. Cryer indicated that there were 200 lawsuits nationwide. I don't know I don't know if that's the correct number or not, but I do know that, of the lawsuits that have been filed, 96 are in California, 50 are in New York, and then, another smattering throughout the country, but none in the state of New Hampshire. And they're not being filed because these are cases that, as Israel Piedra indicated, it would be exceedingly difficult to prove. And the expense to an attorney who takes on one of these cases, who would have to front the expenses for experts and things like that, would be extreme. David Cryer, talked about somebody filing a lawsuit for $20,000 or something like that. That would never occur. The expert fees alone in a case of this nature could likely exceed that number. You would be hiring medical doctors, epidemiologists. It would be exceedingly difficult to bring one of these cases, and that's why you're not seeing them, and that's why you're not going to see them. I want to address the good faith comment that Mr. Cryer made. With respect to good faith, he indicated that good faith would be following the guidelines. Well, currently, the current law, as Representative Piedra mentioned, the current law is that if one is negligent, then they are going to be potentially liable for someone's injuries. And negligence is about acting unreasonably. If you're acting reasonably, you're not going to be found to be negligent. And if you're acting...
Your 3 minutes are up. If you could wrap up, that would be great.
I will. I guess my main point is that this, as Representative Piedra indicated, is a solution in search of a problem. It's unconstitutional. It undermines Part 1, Article 14.
Thank you. Thank you for your testimony. Are there any questions for Attorney Woodbury? Seeing none, thanks for your testimony today.
Thank you, Mr. Chairman.
And call upon is Michael DeMars here. Oops.
Hello, yes. Can you hear me?
Try to stay within your 3 minutes if you can.
I'll try. Can you guys hear me okay?
We can.
Okay, great. So my name's Michael DeMars. I'm the owner of CCI Managed Services in Claremont. I worked with Walt. It was my concern that got him to start looking into this, and I appreciate all of your time. I've got 20 employees. We've been in business over 30 years. We provide critical IT services, mostly New Hampshire, Vermont, but we have clients in 5 other states. My concern stems from the specter of lawsuits, primarily. Where we understand that there's, that the reality is that there may not be a lot of lawsuits being won on this, but the possibility of just being sued and having $20,000, $30,000, $50,000 lawsuit cost just to defend yourself, that type of cost is what's keeping me up at night. I know in working with almost 100 customers that are organizations and businesses, this is a topic of conversation, and most other business owners feel the same way. So it may not necessarily be, I think the reality is we're dealing with something that is creating a lot of fear about litigation, even if that litigation does not result in actually having to pay, as the defendant most likely would be looking at legal fees and probably not more than that. On a personal note, I also belong to a 12-step program. And here in Claremont, we had over 100 members, and we were all meeting in a local church basement, for 5, 6, 7 meetings a week. This is important stuff for those of us that need to do that. And I just want you to know that that church closed its doors to our group a year ago and has refused to reopen them, and they're citing liability concerns. That's their concern. So whether this is something that is real or not, the reality on the street is that you're going to have those types of things happening when people are in fear of being sued over COVID liability. A bill like this could help to open those doors up again and get people the help they need. And that, I think, is a really important side issue. So thank you for your time.
Thank you, Mr. Demars. Are there any questions for Mr. Demars? Seeing none, again, thank you for your testimony today. Call upon Chris Sufert, if he is.
All right, is this working?
It does.
All right. Good morning.
Good morning.
Christopher Sufert of Sufert Law Offices here in Franklin, New Hampshire. I'll be brief. I practiced law since 1984, general practice in this little city. Some of you know me, I'm a pretty straight shooter. I know your chairman there, he's a pretty good lawyer. Tried some cases with him before he became a judge. And then when he was a judge, practiced in his court every year and always had the pleasure. And the courts are where our New Hampshire Constitution says we resolve disputes. Part 1, Article 14 of our New Hampshire Constitution says legal remedies are to be free, complete, and prompt. And every subject of this state is entitled to a certain remedy by having recourse to the laws. Part 1, Article 20 says in all controversies over $1,500, the parties shall have a right to a trial by jury. This method of procedure shall be held sacred. So my businesses are dealing with the same COVID-19 problems as every other business. We got problems with revenue losses, childcare issues, employees working remotely. But none of my business clients, none of them have come to me and said they're threatened to be sued. None of my clients have come to me and said they want to sue a business because of COVID-19 related issues. So while we hear all of the doomsday predictions by the proponents, where's the proof of need to strip our New Hampshire citizens of their New Hampshire constitutional rights? So here's my summary. Almost 4 decades of practice in law, New Hampshire businesses and individuals just need to act reasonably. If you act reasonably, that's all the New Hampshire law requires. The 2012 New Hampshire Supreme Court case of Tom Morgan gives an excellent summary of the New Hampshire standards on reasonableness. The very moral fabric of a civilized society is summed up in their words. Responsibility for personal malfeasance runs through all relations of individuals, each of us to the other. What this bill would do is remove that moral fabric and allow bad actors to act unreasonably unless it can be proven that they acted willful, wanton, malicious, and intentional. I ask that you not pass this bill, and thank you for your time this morning.
Thank you very much for your testimony. And are there any questions for Attorney Sufert? Seeing none, thank you again. The next person would be Nancy Vaughn.
Good morning. This is, for the record, I am Nancy Vaughn, Government Relations Director for the American Heart Association in New Hampshire, and I'm providing testimony in support of House Bill 149. So I do have written testimony that I submitted, so I will be brief and really just point out a couple of paragraphs from that. The health and safety of people and their families is always the American Heart Association's top priority. People with underlying health conditions, including our heart and stroke survivors, are among those at highest risk for complications and death from COVID-19. Since the pandemic, we have chosen to not hold volunteer meetings or fundraising events in person as safety measures for our volunteers and employees. Even as vaccinations roll out and we are again hosting events, the American Heart Association will continue with health safety protocols. When the time does come to resume in-person events, we appreciate the liability protections House Bill 149 would provide should either the COVID-19 pandemic or another public health emergency be present. The prospect of litigation and the exorbitant legal costs is unnerving to organizations like ours, and even a deterrent to reopening. Such litigation could devastate entities just beginning to reopen their doors and even those who have remained open throughout this recent crisis. COVID-19 has had a devastating impact on nonprofit organizations like the American Heart Association because of the fact that we have been doing remote fundraising events. The threat of frivolous lawsuits is a real concern, and nonprofits like the American Heart Association, who are following and maintaining safety guidelines and need protection to safely maintain business. House Bill 149 would not extend liability protection to shield gross negligence or willful misconduct. I also want to just make reference to an example that we have here in New Hampshire. Many years ago, the state did provide limited liability for Good Samaritans who perform CPR on total strangers. And several years ago, well, almost 20 years ago, the state also passed limited liability for automated external defibrillator use, also known as AEDs. This liability protection was also extended to the owners of the AEDs as well as the users of the AEDs. And basically what this did, there were no lawsuits at the time that this law was passed, but we needed to help businesses and others who should have AEDs not fear frivolous lawsuits. And so what this did in the end is it did encourage more AEDs to be out in the community, so saving lives. So in conclusion, I just want to say that we again are in support of House Bill 149. Charitable entities are listed in this in the language to the bill, and we definitely appreciate that. And I urge you to pass the bill. Thank you very much.
Representative Smith, I saw you had your hand up.
Thank you, Mr. Chair. I decided there was no reason to ask a question in light of how long this hearing is going.
Thank you. Representative Horrigan.
Okay, I'll try and make this quick. I saw your letter, Vaughn. It sounds like the primary concern a year ago was not the fear of being sued so much as a fear of your volunteers or your staff people catching COVID, and suffering the obviously severe health things and dying. So is your support for this bill at this point mostly looking forward, your fear of getting sued? So you are viewing this different now that we have vaccines, we have somewhat effective treatments, masks are available and widely used, et cetera. So is your fear of lawsuits looming larger now that maybe the safety concerns are not quite as severe as they were a year ago when this whole crisis started?
Yep. Yes. Thank you for your question. Yes, when we closed down, it was because we were being responsible stewards for our volunteers. Now it is really the reopening concerns. And while vaccinations are rolling out, vaccinations will just protect the person being vaccinated. They can still transmit virus onto others if they are not wearing face masks. And with what we're hearing, people are ready to dispense with wearing face masks, and that is something that we will continue requiring, but we can't control everyone's behavior. So thank you.
Follow up. So the lawsuits it's a secondary concern. Your main concern is the safety of the people you're working with, either virtually or in person. So
yes, our main concern is always our volunteers, donors, and staff. Thank you.
Thank you.
Any other questions for Ms. Vaughn? Seeing none, again, thank you for your testimony. The next person is Tony Sculabrini. And I hope I pronounced that correctly. No? He's there. Yep.
Hello, my name is Anthony Scullambrini. I'm a lawyer in Nashua, a firm Gillen Scullambrini, and I have two things I just want to briefly mention. They deal with the logistics and the finances of a lawsuit. So one thing that I've heard from a lot of people is the issue of lawyers' fees. It's most of the time cases are brought when there is some insurance defense firm on the other side, and I say that because if it's a small business and they have very few assets and the case itself involves relatively low damage, it's generally not financially viable for a lawyer to take that case because they're taking those cases on a contingency fee, which means that the lawyer pays out all of the expert costs and then recovers those costs plus his fee only if he collects. So if there's no if the damages are low, like the one example that was given, a $20,000 lawsuit, no one's going to take that case because of the financial requirements in bringing a contingency fee case on an issue as difficult to track as COVID-19. One other point I wanted to talk about is this idea about how this immunity would operate. So the gentleman from the Business Association talked about how this would work. And I think that what we need to focus on here is the steps in the process. So a motion to dismiss can be filed for some sort of formal or procedural flaw. If we're talking about an issue where there's no factual dispute and only a dispute about what the law means, then that's appropriately determined at summary judgment, which is done after discovery. If we're talking about determining whether or not somebody followed a good faith requirement, that's almost certainly a factual dispute, and that would get settled by a jury. So as written, this bill would not provide the immunities that people think it would, because the way in which lawsuits are dismissed is based largely on the kind of dispute it is. And by including this good faith exception, you're all but guaranteeing that the issue goes all the way to a jury. So I think that this law is unnecessary. You can go to covidtracker.com and see that there are 0 lawsuits in New Hampshire. I think the idea that it would provide some sort of salve for the fears that people have is misleading because of the way in which lawsuits are dismissed. And I think that the financial viability of COVID lawsuits is largely going to prohibit any of them from being brought in the state of New Hampshire. And so I am in opposition of this bill.
Thank you for your testimony. And are there any questions for Attorney Scullambrini? Seeing none again, thank you again for your testimony. The last person who pre-registered to testify is Marissa Chase. You go forward.
Can you hear me?
You can.
Okay, great. Good morning, representatives. Thank you for allowing me the time to speak. I know it's already been a long morning. For the record, my name is Marissa Chase. I'm the executive director for the New Hampshire Association for Justice, a statewide association of trial attorneys representing a wide array of practices in New Hampshire. We have about 400 members statewide. If there are any legal questions you or any of your constituents may have, I can probably find an answer. So I just wanted to reiterate, we are in opposition to this bill. I did send written testimony, which I will not repeat. I just want to make a few key points. Liability is accountability. The only thing anyone or any business needs to do to not be sued is to act as a reasonable person would under the circumstances. And I want to reiterate, under the same circumstances, because that's a kind of flexibility that has evolved in our common law that lends our common law to situations like this pandemic. Our tort system has been in effect since the late 1700s. Attorney Seufert mentioned the New Hampshire Constitution, which the only time the word sacred is mentioned in the New Hampshire Constitution is an article, part 1 article, it's either 14 or 20, that talks about your right to a jury trial of your peers. And I just wanted to kind of respond to some of the comments made by an earlier speaker about other immunities this legislature has granted. And I would respectfully disagree that providing CPR and reopening a business safely should be equated in law as, for Good Samaritan acts. I think if people are, if a person is providing necessary health care to someone, they're probably more worried about saving that person's life, not about being sued, which is how we should all act. And I just don't think that those two situations should be equated. And if a business can't reopen safely, I would respectfully say that just based on societal health, shouldn't that be the top concern, not just focused on liability? But that kind of tells me that you need liability, because liability lends itself to accountability and making sure that everybody knows the rules and plays by the rules. The language in this bill is very vague, not knowing what rules to follow. It's not really clear. Again, Representative Piedra said earlier, willful negligence. Our civil justice system does not recognize degrees of negligence in New Hampshire. There's negligence and there's not. You'll find other statutes and criminal codes that talk about mental states, but that's not in our civil justice system. And one last thing, I just want to say that insurance companies defend businesses. That's why businesses pay liability policy coverage. I don't know of a single liability policy that covers intentional acts. And that is the only case, if a bill like this were to pass, that a business would actually be on the hook for defending a claim against it. Because under our current structure, insurance companies defend a business. The business does not have to hire their own defense attorney. That's why they pay insurance. But if a liability policy does not cover an intentional act, they will tell the business, not our policy, you're out of luck. So I will wrap up and just say, I hope that you vote this bill ITL. There are a couple other proposals, House Bill 255, currently in House Education, Senate Bill 63, which the Senate just voted 21-3 yesterday to re-refer. So if this issue is of concern to you, you'd like to talk further, I sent you all an email. You have my contact information. Please don't hesitate to be in touch. And thank you very much for your time.
Thank you for your testimony. Are there any questions for Ms. Chase? Seeing none, thank you very much. And there are two people I see that have their hands raised who wish to testify. And hopefully they can add something new to our discussion today. The first person is Chris Kelleher. I think you have to unmute Chris Kelleher. Then, since we don't seem to be able to make the connection, then I'll call upon State Rep Maria Perez.
Thank you for the opportunity to speak up, Mr. Chair. I'm calling in opposition of this bill. I have respect for like small businesses and the businesses in our communities, but one thing I don't agree is if the business is being not following the procedures, especially during emergency orders and an emergency situation like the one we have right now with the pandemic, I don't believe this bill, it should be passed because we need someone to keep the businesses online, like make sure that they follow the procedures. To be honest, myself, I witnessed some of the businesses, local businesses. For instance, I went to a gas station and someone wasn't wearing a mask. And I was wearing a mask and someone else was wearing a mask. And the other person asked the person on the gas station, working at the gas station, why this person is allowed here without wearing a mask. And he said, well, I'm not gonna ask the person to wear a mask. How about the rest of the people in that gas station? So that person put the rest of the people into rest, and then that business can be accountable if someone gets sick. So I don't believe this bill should be passed because we need to keep the business accountable to make sure that people don't get sick. In another instance, my husband, he's an electrician and he works in different areas like commercial, residential, and industrial. And then they always have to wear masks. They have to follow the procedures. If they don't follow the procedures, that's when the people, they can get concerned and get a lawsuit. But if you follow the procedures, I don't think it's necessary to have this law.
Okay, thank you for your testimony. Are there any questions for Representative Perez? Seeing none, thank you. And one more shot for Chris Kelleher. If Chris Kelleher can unmute. I don't. And that concludes the testimony on House Bill 149. We'll close the hearing on House Bill 149. We'll move on to the House Bill, open the hearing on House Bill 402. And I'd note that no one signed up to speak on House Bill 402.
Mr. Chair? Mr. Chair, could you just tell us what the count is on the blue sheet for 149?
I can.
Thank you.
There were 9 in support and 57 in opposition.
Thank you.
And on House Bill 402, which we're about to hear, there were 7 in support and 8 in opposition. But our own Representative Sylvia is the sponsor on House Bill 402, and I would call upon Representative Sylvia to introduce the bill, if you would like to do so.
Thank you, Mr. Chairman, and thank you, committee members, for listening to my brief introduction of this bill. We'll get you back on schedule right quickly. This bill is very simple and at the same time probably considered very extreme by some folks. This bill simply puts a very, very high barrier to the takings of property under a state of emergency. One of the things that I love about our state constitution is the fact that it was written with the people's rights in part first. And before they even considered creating a government, they spelled out what the government did not need. And that includes all of our rights, and particularly property rights is the foundation of everything, at least in the eyes of folks that see it that way. So this bill requires, beyond the governor and executive council, it requires the legislature to vote by 2/3 to approve the takings. Now, I did it this way because outright repealing this section of code would have been perhaps a little more difficult, as though this is going to be easy. There are some attachments in other parts of the code that get back to this, and having to do with corpses and real emergencies. And I think the fact that we went 218 years until 2002 to institute this, these whole emergency powers, speaks to the lack of necessity of any of it. And frankly, I would repeal all of it, and we could just go back to pre-2002 and be even more normal. So that's where I'm at. I am an extremist when it comes to our Constitution, and the rights of the people need to be defended by government and not infringed by government. Thank you very much for listening to my testimony.
Thank you, Representative Morgan. Do you have a question for Representative Sylvia?
Oh, indeed I do. Were there any takings of real or personal property that happened during the crisis of the last year, which would have been needed legislative approval by supermajority if your bill had been in place before 2020?
I am not aware of any takings since this was instituted in 2002.
Follow up?
Yes, you may.
As a practical matter, how would we obtain the assent of 2/3 in the Senate, the House of Representatives, if we had a future crisis which made it unsafe for the legislature to meet in its usual in Reps Hall and the Senate chamber, which the Senate has solved, but we haven't? And also, what if this happens when the legislature is not in session? Thank you.
Well, exactly. That is perfectly the point of why we should return to pre-2002. what would have happened pre-2002 and what would happen in the state of a real emergency. And I don't want to diminish the deaths that have occurred because of COVID, but we have heard testimony of possible real emergencies. We won't need to get into gory details of things that would cause perhaps not even the executive council to be able to meet. Perhaps the governor would be part of the emergency and not be there at all. These things are not things that we can plan for. We can do the best we can. And the fact of the matter is, the governor will do what the governor is going to do if there's an emergency. And that's the kind of leadership we have to accept. But it becomes a question after the fact of, was it appropriate measures or not? And what are the consequences if not? So that's the way that I look at it.
Representative Smith, did you have a question?
Yes, thank you very much, Mr. Chair. Representative Sylvia, I'm trying to follow, as I always do, your thinking. And I wonder if you could help me understand why or how you would differentiate between the government's taking of property and the government involving itself in issues of personal privacy.
Thank you for the question. I think I'm stumped. Yeah, I'm afraid I would have to sit and think on that long and hard.
That's fine then, Representative Sylvia. No one could ask for anything more than each of us think about our positions. So I thank you for that.
Representative Birch.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. As I understand already that such takings with compensation already would have to be approved by the governor and the executive council. This would add the further approval of a supermajority of the legislature. Given we're talking about an emergency where fast action by definition is required, how do you see that working? Let's say there's a flood in Concord and there needs to be, or we can go back to Seabrook melting down, and there's a need for the Department of Public Safety to step in and commandeer some property perhaps and the like. How do you see that really working in terms of getting the legislature together and debating and voting?
Well, once again, I think your question really speaks to the flaw in the statute as it sits and why it frankly ought not be there. Any of these possible situations that we can dream up might need a reaction within an hour. And is the governor and executive council going to meet within an hour and take this issue up? It's not sane. The whole statute, it just doesn't have any reason to it.
Thank you, Representative.
Representative Di Lorenzo.
Thank you, Mr. Chair, and thank you for taking my question, Representative Sylvia. Could you describe what the word taking in this instance means?
Well, taking is removing someone's property from them. And there are a couple of different ways that happens. If we look at the statute, pardon me while I'm searching my notes and finding the wrong notes. Pardon me. So in the statute, it speaks of taking possession of private real estate and improvements, or it also speaks of taking title and destroying some possible piece of property. So those are a couple of methods of takings, possibly temporary or possibly forever if you are destroying something. So those are a couple of the ways that the takings happen.
Thank you.
Any other questions for Representative Sylvia? Seeing none, thank you for your testimony.
Thank you very much.
Is there anyone else who desires to speak today on House Bill 402? If you do, please raise your hand. Attendance. See no hands. We will close the hearing on House Bill 402. The next hearing is House Bill 542. I'd note that 284 people signed up in support, 79 signed up in opposition, but there are 22 people who have signed up to speak. And so I think and as I go down through the list, most of them limited the amount of time that they wanted to speak to 2 minutes or not at all, but and a couple did 3 minutes, and I think one person did 5 minutes. But I think I'm going to just limit the testimony to 2 minutes, given the fact that we have so many people who do wish to testify, and we want to hear from everybody. So we will limit the testimony to the 2-minute period of time. The primary sponsor of this
Representative Keating
is Representative Amon. And Representative Amon, would you like to introduce your bill?
Yes, thank you, Mr. Chair and ladies and gentlemen of the committee. Thank you for hearing my testimony. I signed up for 3 minutes. I'll try to keep it to two. We live in an interesting part of the world in New Hampshire and New England because a lot of the original migration from Europe to this part of the world was driven by this issue of religious freedom. And so the original bill, I'll speak to that first. And then you should have gotten an email yesterday with an amendment that merges the original 542 in with the original House Bill 440. I'm prime sponsor on 542. I'm a co-sponsor on Representative Kofalt's Bill 440. And I'll get into those details in a minute. But whether or not you are a religious person, and whether or not you are a practicing religious person, you benefit, and we all benefit, by living in a society that gives wide deference to religion. And the issue is not religion, the issue is your freedom of conscience. That's really the issue. And that freedom can include believing in a deity, believing in no deity, or having different beliefs. And the state stays clear of your internal belief system when it comes to religion, the label we give this for religion. Societies where the government imposes restrictions on religion tend to be authoritarian societies. Somehow government sees the concept of God as a competing idea and tries to crush it or tries to keep it constrained. And you see that in, communist China, where they're taking down crosses on churches, or they're forcing churches to put a picture of Mao in the back of the church, or they're rewriting the Bible so that it fits with communist doctrine. So when the state of emergency took place here in New Hampshire, we had an interesting situation that I think is unprecedented. I don't know if it's happened before in New Hampshire or even in our country. And that's when the government for a period of time, period of uncertainty, shut down churches. And so that was an interesting moment in time. And that prompted the original idea for House Bill 542 to make sure that houses of worship had their deserved carve out in the state of emergency RSAs. So you see that in House Bill 544 or 542, I'm sorry, and that's line 10 on the original bill. To guarantee the free exercise of religion, the right of people to peaceably assemble, and talks about the First Amendment and the Constitution, and Article 5, Part 1, Article 5 in the New Hampshire Constitution, which contained the free exercise clause. I could probably go on a lot more than 2 minutes, so I'm going to skip over some of the things I'd like to say.
We already have, so.
I have, okay. I'll try to wrap it up. It's a big topic. So the Amendment 0623 takes the original 440 bill and combines it with 542. So the original 542 can be found on page 4, line 24. So that's the kernel of the original 542. The rest of the language is from the original 440 bill. And if you recall back when there was testimony on 440 with Representative Kofalt, he put that bill in before the Mack decision that came from the U.S. Supreme Court that dealt with the exercise of free, or the free exercise of religion, and it gave a strong statement on what New Hampshire's free exercise clause means, and that it's much stricter than what the federal government's clause means. So that bill was removed, and that bill was amended. But there's been discussions that we should codify the Mack decision in state law, and that's what the original 440 did. So that's the impetus behind the amendment, is to combine 542, protecting religious exercise during state of emergency, combining it with 440. They're completely related subjects, so that we put the Mack decision into statute.
And we've already spoken about 4 minutes here, so if you could just wrap up, that would be appreciated. You all set? Okay, Representative Horgan, did you have a question?
Yes, I just wondering, is there a constitutional issue here on giving privileges to overtly religious organizations as opposed to other organizations like atheist groups, or let's say, just hypothetically, I had a study group which gets together every week to study critical race theory. So would you, is that you feel that maybe something you need? So do you have a problem with the bill as written, carving out religious groups from other people discussing sort of non-religious philosophical topics? Thank you.
If you consider your study group a religion, then I think maybe it might apply. But if it's a academic study group, then that would be a different realm of law.
Representative Alexander.
Thank you, Mr. Chair, and thank you, Representative Ammon. My question is regarding like ways people can abuse this if it's enacted. So say over the summer, I decide I want to have a barbecue with a bunch of my friends during a state of emergency. And, I have a bunch of people over my house and we read, a verse of the Bible. Would that qualify as a like an opportunity for a free assembly? If we just maybe read 1 or 2 verses, then continue on with our day.
Could you elaborate on that scenario? I mean, what kind of enforcement would you expect to happen in that situation?
I guess that's my question is could this be construed or abused, in a situation like that?
So that would apply to narrow tailoring. So if you look at the bill, it's page 4, line 12 and 13. So that would be the test that the government would apply to what you're doing. And is there an essential and compelling interest for the government And what is the least restrictive means of furthering that compelling interest? So, you know, if you're actually having a Bible study that might happen to have a barbecue at the end, the government would have to use the least restrictive means to enable your free exercise of religion.
That's very helpful. Thank you.
Thank you.
Representative Birch.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. I thought I heard you suggest that this, under COVID, was the first time that the churches were closed during a pandemic.
I said to my knowledge, I said.
Okay. Were you aware that during the 1918 influenza pandemic, churches were closed worldwide?
Do you have a reference for that so I can look it up?
Just Google churches closed 1918 pandemic. You'll see lots of articles.
And the government closed the churches, or did they voluntarily close?
Well, that I don't know. They closed. Many, not all.
Okay.
Thank you.
Are there any other questions for Representative Allen? Seeing none, thank you for your testimony today.
Thank you very much.
Yeah. Next person to testify is Ken Barnes. He's on the line. Don't see him. And next person to testify would be Jessica Wheeler Russell, if she's there. If you're there, raise your hand. I don't see that person. We'll call upon, I'm going to indicate that everybody who has signed up has signed up. All the remaining speakers who have signed up in support. So we will hold people to that 2 minute, and I'm sure we'll get everybody in at some point in time. So the next person is Representative Greason. Jeffrey Greason.
Good morning, Mr. Chairman and members of the Judiciary Committee. I'm Representative Jeff Greason of Wentworth. I would gladly add my name as a co-sponsor of this bill if I could, so thank you for allowing me a couple of minutes to express my support in House Bill 542. The events of the past year have demonstrated that government tends toward expansion and abuse of its powers and will infringe on people's rights if it is not constantly held in check. And if we allow government to use the excuse of an emergency to infringe upon rights, then emergencies they will give us. I personally know 3 pastors who directly faced such infringements in the past year, one of whom was fined $112,000. It didn't matter that people remained in their cars. It didn't matter if services were being held outside. It didn't matter that reasonable care was being taken to protect people inside and out. There was an attempt by government to shut down God-given constitutionally protected rights in the name of an emergency. And it was one of the very first actions taken by government, going as far as to label church attendance as super spreader events, thus stoking fear and panic and bigotry against those who would attend church services in person. These pastors were these pastors were put in a situation that no pastor or Christian or anybody wants to be in, having to decide between obeying government or obeying God. Their decisions were not made with any malice, and they were prepared for the consequences, but the decision of the government to go after these pastors was arbitrary, capricious, and abusive because no police was ever sent to the local Walmarts or Home Depots that routinely have larger attendance indoors than these churches, and liquor stores remained open. No government should be so comfortable wantonly trampling on people's rights, even under the guise of an emergency. The Constitution does not limit what the people can do. It limits what the government can do, including during emergencies. We should not need this law, but we do. The courts got it right this time in reminding governors and other officials about religious freedom, but the meanings of the words of the US and the New Hampshire Constitution and other state constitutions have become increasingly more vague, and the citizens of this country have been found to not have standing in our own courts with greater frequency. Next time is not worth the risk. Religious freedom is found in the First Amendment because it is one of the first things that tyrannical governments take away. So please send House Bill 542 to the floor with a unanimous OTP recommendation so that regardless of your faith or lack of faith, you'll be free to exercise it without infringement, even during an emergency. Thank you.
Thank you. Representative Horgan, did you have a question?
Oh, I guess so, yes. You mentioned the pastor who was fined even though he had a drive-in service, and I don't know that particular story, but was that pastor taking the precautions that he did simply out of fear of the government, or was he doing it primarily out of fear of the pandemic? And
the pastor's name is Charles Hamilton at King James Bible Baptist Church in Greenville, Mississippi. He's actually a personal friend of mine. And in trying to accommodate all of the guidelines, trying to follow what would be considered reasonable protocols, Pastor Hamilton decided to hold a drive-in church service. This was right at the beginning of all of this, and yet 20 police cars showed up at Pastor Hamilton's church. That means 20 police officers were not out arresting rapists and murderers. No, they were fining every person who attended the outdoor drive-in church service $500, including Pastor Hamilton. Yeah. So that's the kind of abuse that that pastors faced.
Thank you.
Thank you.
I'm sorry.
Not here in New Hampshire.
Any other questions?
No follow-up.
Representative Green.
Okay. Any similar incidents in New Hampshire? Okay. Thank you.
I'm sorry, Representative Horgan. I didn't. If you asked me a question, I didn't hear it.
Were there any similar incidents in New Hampshire? I mean, I can look up the King James Bible incident. I don't know how many people were there. 20 police cars may have been reasonable, unreasonable, depending on the size of the crowd and the size of the place where they were assembling. But I mean, we had almost that many. We had like a number of police officers, probably that many just for our house session, including the drive-in session that we ourselves had in my town of Durham.
Well, if you're comfortable sending 20 police officers to a church, I don't know what to say about that, but in the state of New Hampshire, I am not aware of any pastors that were fined anything, because our governor responded very quickly after a lot of this started making national news, and we went from having to be completely shut down to, well, at least we could open and have 10 people in service. So the governor responded rather quickly before he could be sued.
Thank you.
Follow up? Oh, you probably follow up. So
one last
okay, so I can't speak to the governor's state of mind. Do you favor treating religious organizations and then perhaps non-religious organizations that wish to have meetings differently in the law, or do you think maybe we should prefer modifying it to bring in a wider range of organizations? So.
Well, if I'm reading the First Amendment of the U.S. Constitution, the freedom of religion is expressly stated. And so it's not like we have to carve out anything special for religious freedom. It's already there. Now, as far as any other philanthropic organization or philosophical organization, if you get yourself declared a religion, then you would fall under that. Atheists have been determined to be a religion as well, so atheists can get together under the religious freedom. So it's a all for one if it's a religion, but it's already carved out. That's why I said that this bill should not even be necessary, but it actually is necessary because government keeps toeing the line or overstepping it.
Thank you. Are there any other questions for Representative Greason? Seeing none, thank you for your testimony today.
Thank you very much.
Yep. We'll call upon Ian Hewitt.
Good morning, Mr. Chairman. Can you hear me?
We can, Ian. Thank you.
Thank you. I'll just respond to a few of the points that have been made already, and then I'll take any legal questions. I guess I'll respond first to Representative Horgan's last point about there not being any fines of churches in New Hampshire. That's true. There have been no fines. I think this is first and foremost a preventative measure. In light of what we've seen in other states, it's appropriate for the legislature to think ahead about problems that might arise in the future, just based on what we observe, and try to fix those problems before they come up. I will say that Governor Sununu's executive orders did initially have provisions which did treat churches more restrictively than other similarly situated kinds of entities. But fortunately, before those provisions could be applied to anyone or enforced, it was brought to the governor's attention that those provisions were likely unconstitutional, and the governor and his office recognized that and removed those provisions. So it is just something of a natural tendency of state governments, especially in a state like New Hampshire, which is more secular, to just not deem churches to be particularly important. And that's an important reason to have a protection like this in state statute. The next governor might not be as forward-thinking or as benevolent as Governor Sununu was. As far as this has come up a couple times, the idea of special protections for religion and not other groups. I think that both the federal constitution and our state constitution make that value judgment that religion warrants special protections. There's special free exercise clauses in both. There's not special protections for labor organizations or other kinds of groups because of the particular importance of the topic of religion. And we see this already in existing law. In the Supreme Court case, Hosanna Tabor, for example, which was 2012, the US Supreme Court held there's a ministerial exception. The government flat out can never tell churches what ministers to hire and fire. That's just not true of other kinds of organizations. So this statute, I think, just reflects that value judgment. And you could say this really about any constitutional right. You know, abortion is a constitutional right in the US. Other kinds of medical procedures aren't. The Supreme Court's decided our Constitution makes that value judgment. And it might obviously, I might have some objections to the result, but not to the idea of some things being warranting special constitutional protection. As far as Representative Alexander's question about the idea of abuse, people might say that. Yeah, sure. Well, I'll point to the New Hampshire Supreme Court's case in the Mack decision, which you can easily pull up online on page 21 of that decision. The court said there the compelling state interest balancing test has proven to be a workable standard in free exercise cases. So I just don't think there's any evidence, and I think this is true at the national level as well, that this is actually going to lead to all kinds of chaos or nullifying of ordinary laws. The US Supreme Court also addressed this issue in the Sherbert decision in the 60s, and it said, we don't see any evidence that this kind of malingering or deceit is going to be a real problem. And if there were some evidence, it probably wouldn't be sufficient to justify imposing on free exercise of religion. So for those reasons, I think that it's important to have some special protections for places of worship in a time of emergency, especially, but also generally.
Thank you, Mr. Hewitt. Are there any questions for Mr. Hewitt? Seeing none, thanks for your testimony today.
Thank you.
How about Scott Mitchell? Scott Mitchell there. Yep.
Oh, yes. Good day, and thank you for hearing me. Thank you, Mr. Chair and the committee members. I appreciate you taking the time to hear us. My name is Scott Mitchell. I'm the senior pastor at the New Hampton Community Church in New Hampton, New Hampshire. I really do urge you to support this bill because churches have a very significant part in our communities. Even in New Hampshire, where it may be a small parts in our small towns, it really does provide a large and significant impact in our communities. Through this pandemic that we've been in, we have been actively caring for people in our community, people in our our area have been doing grocery shopping. They've been providing meals. They've done assistance for groceries, as in financial assistance. We've been doing wellness calls, helping with heating supplies and other ways, giving people rides to hospital when that was appropriate, or I should say to doctor's appointments when that was appropriate and safe. And I really believe that we can be trusted to safeguard the health and of the people in our congregation and the surrounding communities. Churches really are essential for the emotional and spiritual health of our communities. And it is very important that we uphold this and allow the government to give guidelines on gathering, but allow churches to make the decision and be wise and focus on the health of our people. But it is essential for churches to be able to regulate and know when we can gather and not be regulated by the government. So I appreciate your time and the opportunity to speak before you, and I'm happy to take any questions you might happen to have for me.
Thank you, Reverend Mitchell. Thank you for staying within your time. Are there any questions for Reverend Mitchell? Seeing none, thank you very much. Next person is John Barnes. Again, all the people who are remaining to speak or signed up, pre-registered to speak, are speaking in support.
Can you hear me okay?
We can.
Great. Thank you so much. As you said, my name is John Barnes. I'm the pastor of the State Line Baptist Church in Portsmouth, New Hampshire. And my wife and I live in Pelham. We've lived there for 7 years. And actually almost 8 years. We started the church. State Line Baptist Church is a church plant in Portsmouth, and we'll tell the whole story, especially since I have 2 minutes. But I want to reference an email that I sent to the to Governor Sununu last May and to the reopened committee and such in reference to the church. Is kind of echoing what this pastor just said a moment ago, but I liken the church, you know, probably many of us even in this committee have, and if you don't, that's fine, but many of us have some form of a church relationship. And I like to liken the church to many different things from a spiritual perspective, a spiritual hospital. But I think the best way, and the email says this a little bit, so I don't want to just be redundant, but I really liken the church to a family, you know, and I can't help but think even just 2 days ago on Wednesday, I had the privilege to officiate the funeral at the military cemetery there in Concord for a 93-year-old World War II veteran, Linwood Bink Leslie. Served our country, an amazing man who really I've only known personally for the last maybe 6 to 8 months, but the door opened because about a year and a half ago, I had the privilege to start doing services on Tuesday nights, church services on Tuesday nights at Maple Suites, which is a retirement community in Dover, just about 20 minutes from our church. And I say that partly because of just thinking of the many facets of the church and the privilege to serve and love the people in our communities, as this previous pastor just said. And again, if it's not, obviously I realize it's not the immediate family, but it's an extended family. And just the privilege to minister to the Leslie family, and then the folks at Maple Suites. And we respected, of course, the 4 to 5 months that we needed to wait to be able to be in there at Maple Suites. But I echo the sentiment wholeheartedly, the essentiality of the church. And I want to thank you for giving me 2 minutes to share just a little bit of my heart. And thank you for listening to all these reports and support of this bill.
Thank you. Are there any questions for Reverend Barnes? Yes, Representative McLean.
Thank you, Mr. Chair. I'll be brief. One of the things that's always interested me is because I'm a Catholic, and so there were rules around our church closing. I saw the Home Depot stay open, and I saw the grocery stores stay open, but we did see, and I felt that churches were essential. In your communications back and forth with the governor and these various committees, did he give you any communication as to why there were restrictions or limits on your congregation? Did he give any additional reasons behind that in that communication?
No, sir. No, sir.
Thank you.
Yes, sir.
Any other questions? Seeing none, thank you again for your testimony today.
Thank you for the privilege.
Yeah, I'm just going to ask everybody who is going to remain to speak is speaking in support. So if you could just be, we're really short on time. If you could just be succinct, and if you have anything additional to add, that would really be appreciated. Okay, next person is David Carlson.
Good morning.
Good morning.
My name is David Carlson. I thank you for the opportunity to speak in support of this bill. I'm the pastor of Gospel Baptist Church right in downtown Manchester, one half a block off of Elm Street, right behind the Red Arrow restaurant. I've been the pastor here for 29 years, and I'm supporting the regular scheduled worship and church services in the event of such an emergency, which if 1800 and something was the last time, hopefully we got it over with for another 200 years, that'd be good. We work with many people off the street, and many of them I haven't seen in a year. They have spiritual needs, they have emotional needs, their family situations are impacted. We've made some adjustments which have been very helpful. We've gone to Facebook Live, and we did have to have 10 people, and then, you know, a little bit bigger amount, now half of our occupancy. And so we've done social distancing, separated the pews, taped off marks on the floor. People wear masks. They have and wear gloves and, you know, different things. I work extensively with the incarcerated, those who have gotten out of jail, those who've gotten out of prison. And we are probably averaging 20 to 30 a week here at church from that type of background. And I was listening to, I think, a news article this morning on the radio. They were talking about the recidivism rate. And that's something that we always want to eliminate, people going back. I think church is really important with that because it connects people with the community, with the pastor, with faith. And we've seen so much growth in this area. And we've seen that just drop off in a major way. But people turn to church, they turn to religion, the Bible, assembling with each other for support and encouragement. We should be allowed to do this safely, at least as safe as going to a lumberyard or a grocery store.
Carlson, if you could just wind up, that would be appreciated.
Sure. Thank you.
Good. Okay. Any questions for Reverend Carlson? Seeing none, thank you for your testimony today.
Thank you.
Edward Carnahan.
Yes. Can you hear me?
Again.
Well, I want to thank you, Mr. Chairman, committee members. I'm Reverend Edward Carnahan, pastor of Portsmouth Believers Church, and I support HB 542. I believe churches are essential at any time, but especially during a time of crisis. One of the things that I want to make in the few minutes that I have here is why churches are essential. This is never a question that's asked of Walmart or Home Depot because it's obvious why they're essential. But for churches during a time of crisis, three things always happen in society during a time of crisis. Fear, panic, and distrust of the government. When left unchecked, all three can increase the severity of the crisis and hinder the government's role in solving the problem. Meeting people face to face brings a sense of peace, normality, and inclusion, which will calm an individual and relieve stress. I'll conclude by saying in 1933, during his inaugural address, Franklin Roosevelt, who at the time was facing one of the greatest threats to this country and the world, said, "We have nothing to fear but fear itself." He recognized that fear in people stops the progress necessary to overcome the crisis. The church is by far the most qualified organization in existence to deal with this effectively, and this is why I deem churches essential. Thank you.
Thank you for your brief testimony. Appreciate it. Any questions? Seeing none, again, thank you for your testimony today. Justin Corkum.
Can you hear me?
We can hear you.
I'll keep it brief as well. My name is Justin Corkum. I just want to thank you, Mr. Chair, and members of the committee. I am in support of House Bill 542, and I'm not going to, most of the same reasons have already been mentioned. I've seen the increase in anxiety, depression, hopelessness, particularly in the young people that I am working with in my community, and when things shut down, how important connection is for them. And they were separated from not only friends, but separated from worshiping God together as a community, and really didn't have a place to be spiritually encouraged or more emotionally supported. And I think there's been so much emotional trauma throughout this year, and I'm sure each of us have experienced it in one way or another throughout 2020 and even today. And so I think for a lot of our church members, it's just so important to be able to gather together and to be encouraged and really empowered to face the next day with purpose. I mean, for us church community, faith is what fills us with purpose. It gives us a reason to live. And so, it reminds people that they're loved by God, they're loved by the people in their community, and they're here for a reason, and that they have a purpose. And obviously, like mentioned before, grocery stores, gas stations, clothing stores, nobody's arguing that all of these places, hospitals, they're very much essential. But just to express how we feel the spiritual and mental well-being that churches provide people is just as essential, if not more, in my opinion, as these other essential services. So I just want to thank you for your time. God bless you.
Thank you. Any questions, Mr. Corcoran? Seeing none, thank you again for testifying today. Jim Gazowski. If you're there, raise your hand. Don't see him. Ed Harkey. If you're there, raise your hand. It must be Pastor Ed. You got it? Okay, Pastor Ed.
Thank you very much. Members of the committee, I'm not going to belabor. I'm Pastor Ed Harkey of Trinity Lutheran Church in Keene, New Hampshire. God bless you today as his ordained servants and servants of the people. I won't belabor anything else that my brothers have said, colleagues before and after. I'm just going to I forwarded you my statement, and you have that before you. But I will just quote the preacher, the son of David, in Ecclesiastes 4, when he says, "Two are better than one, for if they fall, one will lift up his fellow, but woe to him who is alone when he falls and has not another to lift him up. A cord of 3 strands is not quickly broken." And that speaks to what everyone else has said. And so I will defer to them as I can add nothing else to what they have said. Thank you for your time.
Thank you so much. Are there any questions? Seeing none, thank you for your testimony. Thank you for being brief. We appreciate it. Ron Moore, if you're there, if you could raise your hand, that would be appreciated. There you go.
Good morning. Can you hear me?
You can.
Very good. Good morning, Mr. Chair and the members of the committee. Again, thank you for holding this meeting so we could speak to this issue. My name is Ron Moore. I'm senior pastor of the church at the intersection in Merrimack. I've also sent you an email with these statements. So rather than reiterate what everybody's already said, I agree to these other pastors and the comments that have been made, the constitutionality of this. Also, but the history of New England and the church in New England has been powerful. The biggest colleges up here, the most esteemed universities, they were started by people who were religious, and the church was core to that. And church, of course, can be without Sunday morning, or can it be? That's the big question, and it really can't be. I've heard a couple of the other pastors mention that young children, young people, and seniors were affected by this, and indeed that was the case in our church. And we've noticed in the last few weeks being able to breathe a little more, obviously over last year, trying to be safe, trying to be prudent, trying to be within state protocol. We did all that, but we've been able to open up a little more here lately. And people are hungry for the fellowship and the communication, the interaction. So again, I can go with the other pastors and tell you that people need this. It does contribute to the community. And I would say this too, in ending, Home Depot and Walmart went around 200 years ago when the universities were being started and towns were being established. The church was, and it assisted in that and continues today. So I think it's a very important part of the culture of New England. And I would just say that and encourage you again to support HB 542. Thank you for your time, and I appreciate your service.
Thank you very much. Your testimony is appreciated. And are there any questions? Seeing none, thank you very much. Robert O'Sullivan. If you're there, raise your hand so we can see you. Don't see him. Nathan Pickowitz.
Can you hear me now?
Again.
Good morning, Mr. Chair, members of the committee. My name is Nate Pickowitz. I'm the pastor of Harvest Bible Church in Gilmanton Ironworks. I appreciate the opportunity to show support for HB 542. The framers of our Constitution understood that people of faith are bound by conscience to fulfill the mandates of their religion. And while there is a great diversity of religious conviction in New Hampshire, these convictions reside at the very core of who we are as people. In other words, the corporate religious gathering is essential, no different in importance than purchasing food, receiving medical care, or engaging in gainful employment. If the COVID-19 crisis has taught us anything, it's that the mental, emotional, and spiritual needs of a person are just as essential as their physical needs. Furthermore, our church and other Christian churches like us are commanded to assemble ourselves together corporately, something we cannot faithfully observe online. We are called to gather together, not leaving anybody out or limiting their access through capacity restrictions. And while together, we are called by God to corporate prayer, singing, observing sacramental ordinances, and fellowship. Without these elements present and active, we're disobeying the dictates of our conscience as we would be defying God. We regularly engage in practices designed to protect our church from all forms of harm. And we do this not because the government directs us to, but because we exercise discernment and compassion toward one another. By upholding HB 542 and our religious freedom to gather for peaceful worship, we are both honoring and obeying God, which is essential for us, as well as honoring our obligations to submit ourselves to the government. Thank you.
Thank you. And Representative McLean, did you have a question?
Yes, with your indulgence, Mr. Chair. So thank you, and thanks for taking my question. So we've heard a lot of folks in government go out of their way to recognize healthcare workers, recognize grocery store workers, recognize all these essential areas and work with them to make sure that they're able to stay open. And in your experience, in your dealing with the folks in government, has it been your experience that you've been treated in the same way with that same level of recognition and that same level of work to get you opened up in the way that these other sectors were opened up?
Thank you for the question. I appreciate the opportunity to respond. I was on a conference call with several other pastors with Senator Bob Guida. He was wonderful to work with. He was an advocate for us. But we were, the general experience that we had was that it was very, very slow and very, very sluggish to get us open. We were under the impression we would be shut down for maybe 2 to 4 weeks, just like the pandemic in 1918. We ended up, our church stayed closed for 11 weeks, and we pushed hard, but we want to observe our subordinates to the government. And so we worked hard to be patient, but we did not feel like we were receiving the same level of importance or even watching the briefings online, little to no mention of religious organizations. And so we did not, in my personal opinion, receive the same treatment.
Thank you. Thank you. Are there any other questions? Seeing none, thank you for your testimony today.
Thank you very much.
Juan Saw.
Thank you for your time and service to our country and our state. I am the pastor of Lifeway Church in Derry, New Hampshire. I've been pastor there for 21 years. It's been one of the greatest honors to serve our community. I just have to say that serving our community for all these years during many of the crises we've had with snowstorms, even the ice storm in 2008, we have been able to provide effectively for the spiritual, physical, emotional, and mental needs of the people. And it has made for a better knit community. We've hosted many block parties where we give everything for free. And I believe the church, like I tell our people, is like a lifeboat in the middle of Titanic emergencies. We want to be there when there's needs, when people are drowning in hopelessness, in fear, in distress. They need someone to stand with them. The church is ready to do that. History attests to that in the 2nd and 3rd century, in the plagues of Antonine and Cyprus. Many of the Christians went out there to help their communities, and I think we will be a better and stronger state for that. And I appreciate you listening, so I fully support this bill, and I hope that we can continue to strengthen our communities and make them healthy by serving as Christ served us. Thank you so much.
Thank you for your testimony. And are there any questions? Seeing none, again, thank you. There are 6 more people who are registered to sign up. I hope you can be brief in your testimony, and if you have something new to add, that would be appreciated. Paul Sontag. If you're there, please raise your hand. Don't see.
So he's up there.
Huh?
He's up there. He has to unmute.
I don't see him on the screen.
He's up there. It's in the middle. He has an old Zoom, so we haven't promoted him to a panelist. You can unmute.
Mr. Sontag, can you unmute?
Hello, are you there?
Yes.
Sorry about that. So my name is Paul Sontag. I'm pastor of Light of the World Church in Milford, New Hampshire, the Souhegan Valley. I think I do have something new to add to the conversation, though I agree with my fellow pastors. We're in the Souhegan Valley in southern New Hampshire, where we serve as a faith community as part of the fabric of our community, not independently. The faith community in Souhegan Valley has a history of standing with our community partners, not as a standalone resource. We view each other as co-laborers, collaborators, and we actually like each other, and we meet each other weekly on Zoom meetings and trainings, working for the same goal as a healthy community. When COVID hit in last year, a year ago, the faith community were already in a position to work alongside our community agencies and leaders, schools, Boys and Girls Club, NAMI, Bridges, Milford Welfare, Share, and provide food and other essential basic resources for the poor and needy, especially the elderly. Our faith community provided a strong volunteer basis, many of whom had attended and received trainings so that they could be more effective in their communities. Our own church offered a recovery coach training last year, where 5 members of our church are now available to serve productively in recovery centers, which the faith community operates in the Souhegan Valley. We know that in these emergencies, needs of the recovery community soar. Our faith community was intentional about becoming a good Samaritan, which is the essential call of the church. It's called the Great Commission. Meeting the needs of the underserved is certainly good news. Years ago, we formed a multi-church outreach team which organizes our network of churches to respond when needs suddenly arise, like an emergency, like a pandemic. We plan to be ready to serve because we were intentional about building partners and networks with proven success. So my question is simply this: why would you want?
Could you finish up your?
Yep. I guess I could finish just asking the question is, why would you want to undercut the health of our communities by eliminating the faith community from participating in this particular way? Thank you very much. We are essential.
Any questions for Reverend Sontag? Being none, thank you for your testimony today. Next person is Patrick Testerman. Yes, you may have to unmute.
Okay, here I am now. Can you hear me now?
We can.
All right. Okay, ladies and gentlemen, I'm Patrick Testerman. I'm a pastor and in Loudon, New Hampshire. I'm also a retired military combat veteran and have since my retirement served as a New Hampshire law enforcement officer, taught constitutional application at the primary, high school, and university levels. As a worshiper of Jesus Christ, called to take up my cross daily and also send into this world, I'm deadly serious about both my faith and my constitution. When any of the branches of government fail to execute their duties, overstep their authority, it's the responsibility of the other branches to hold them accountable. If necessary, to take appropriate steps within their own authority to prevent repetition of these abuses. I want to be clear. I believe Governor Sununu has done an extraordinary job in extraordinary circumstances. We look at other leaders across our nation and the world, we can see a wide range of actions from reckless indifference, fearful timidity, and outright authoritarianism. Within or among those leaders, Governor Sununu was in the top, constantly balancing state interests and constitutional rights, risks and benefits, information and the unknown. I was privileged to be a member of his task force and leader of a smaller working group that helped formulate guidance for reopening houses of worship last year. I found him in his office in most cases to be very reasonable and eager to move that process forward, and I thank him for that. Yet mistakes were made, overreaches occurred, and at two particular times I joined with other pastors to call out those abuses and eventually end up in a precipitous conflict. Details of that I will send on with my extended remarks. Though I disagreed with the governor in these cases, I did not call into question his integrity, character, efforts, or overall performance. However, I do believe that it's time for the governor and his legislature to take take action to prevent future oversteps of authority. When passed by the court and Senate and signed by the governor, this will begin the corrective action. It will help secure vital freedom to worship as guaranteed by the First Amendment of the United States Constitution and Part 1, Article 5 of the New Hampshire Constitution, regardless of the distaste for that of Representative Horgan, evidently. I ask for your support of this bill.
Thank you for your testimony. Yeah, Representative Horgan, do you have a question? You need to unmute.
Called me out by name. I'm not sure whether I guess probably a violation of the rules. So that's actually I had a more friendly question, which was it's a familiar name around the State House. So you're related to Representative Testerman and then also Karen Testerman, his wife, the former governor candidate?
I am.
I don't think that's an appropriate question, Representative.
Okay, thank you.
I don't think
anyway, I mean, yes, I just want to say I'm still I'm listening to the debate, and I'm allowed to think whatever I think, and so I probably didn't feel good to have somebody impugning my motives. It's I'm going to reach a decision about this bill when we have the exec session, and that's what I was sent here to do. So that's what I'm doing. So
may I respond?
Actually, no. Are there any other questions for Mr. Reverend Testerman? Thank you. Thank you for your testimony today, Mr. Reverend Testerman. Okay, the next person to testify will be Daryl Van Wagner.
Hello there, can you hear me?
We can.
Hey, thank you for your time. I know the pastors have said many things that I agree with. So the value that I could add, yes, while I am a First Amendment guy and when in doubt, follow the First Amendment, I feel like you may need to hear from one of us stating or speaking to your possible fear that we're not big boys and girls, that we might just go off half-cocked because of a religious pursuit and put our folks in danger. We love these people. If they are to pass away from a decision, we're the ones who are going to bury them and, perform their funerals and cry with the families, right? We love our community. We're taking calculated risks to assist them in their time of need. And we're not interested in just declaring our rights. I mean, we just want to continue doing what we've always done and be a blessing to the community. And the value that we had, the place where the state really needs us. During the lockdowns, we've seen so many cases of anxiety, physical abuse, substance abuse, depression. We've seen some suicides. We've encountered many single parents struggling to take care of their children who are now being schooled at home while trying to figure out how to work their jobs or maybe not have jobs. Unemployment had broken down in many cases. Families were hungry, didn't know how to find clothing, food. Just finances were a mess. And the church is jumping into those messes and assisting. And if the church were to just close down, and I'm not only talking about Sunday mornings, but all of the involvement that they do within the communities, within house-to-house ministry, within large public gatherings or small private gatherings, we're going to use wisdom, but man, you'd miss us if we were gone. Thank you.
Thank you for your testimonies. Thank you for staying within your time. Much appreciated. Are there any questions? Reverend Van Wagner? Seeing none, thank you again. There's 3 more witnesses. The next one is Tim Virtulono.
Good morning. This is Tim. I'm the senior pastor at Real Life Church in Laconia, New Hampshire. And thank you for, on a moment of levity, thank you for taking a stab at the difficult last name. I am so thankful for the job that you all do, and a group of local area pastors, and I pray for you and your colleagues very regularly. And I'd like to, like my other colleagues, urge you to support House Bill 542, because as been stated so well by many others already, we not only provide spiritual services to our communities in the Lakes region, but practical services as well. Back in March, we had just completed our the first phase of our building project to get into our new building in downtown Laconia, and had one service and then shut down. And so many people from our congregation we have not seen since last March. We've been in communication with them, as many pastors have done so as well. But there are a lot of people that we serve, not just in a spiritual capacity, but as other pastors have said, in a needs-based capacity. And if we were to just simply keep the doors closed, we would figure out a way to make it work. A friend of mine commented, said, just like that, we all became televangelists, halfway jokingly. And so we have done our best to turn on a dime. But I want to urge you to support this bill, just because there are many needs that we provide the answers to. And again, like I said, thank you for your time. Thank you for how you serve us. And I really appreciate this time to share this request to you. God bless you. Have a great day.
Thank you for your testimony. Thank you for staying within your time. Any questions? Seeing none, thank you very much.
Yes, sir.
Malcolm Widness. See a hand up.
See BC Gary.
We don't see Malcolm Widness. Matthew Worrell or Worrell.
Good morning. My name is Matthew Worrell. I'm pastor of Grace Christian Fellowship in Winchester, New Hampshire. And I am been patiently waiting to be able to just tell you of my support of HB 542. We had closed our church for 2.5 months last spring and witnessed much distress among our congregation and even our community. It was sad to see depression, anxiety, and a general sense of fear overtake many in our congregation. I believe the church is an essential entity that many in our society look to for comfort, direction, and compassion during stressful times, i.e. one thing was why we're shut down is the number of funerals I had to turn away. And I had to talk with those families and try to explain to them why, as a church, we can't meet this need of their family because the state has closed us down. That was a really sad and very, very difficult time for myself, and I'm sure other pastors had the same stressful difficulties. When church was closed down, those people lost the sense of support that they looked towards. You know, when it comes to funerals and our bread food ministry, we had to shut down. These are things that are essential, not just spiritually, but practical, essential needs for families in our community. We had to close down, yet big box stores were allowed to stay open. Other stores were allowed to stay open. Liquor stores were allowed to stay open, but we had to close down. We are well aware of how to care for our community and congregation, and we can be trusted to install the necessary guidelines to keep our community and congregation safe during these times. We are well able to govern ourselves. The scripture is clear that we are not to forsake the assembling of ourselves together, and we have the privilege and responsibility to govern ourselves and never be fully closed down. I thank you for giving me the honor of talking to you and giving you my thoughts. The church is essential in our communities, and that has been very clear during this time, that period of time that we had to be shut down.
Okay. Thank you for your testimony today. Are there any questions, Reverend Worrell? Seeing none, again, thank you. That concludes the list of people who pre-registered to testify here today. Is there anyone else who feels compelled to testify? Seeing no one, we will close the hearing on House Bill 542. We'll be executing on that next Wednesday. Next hearing is on, we are way behind this morning, I know, so I'm not going to take a break. If people need to, if members of the committee need to take a break and leave for short periods of time, that's fine. It's certainly to be understood, but I don't think I can take a break at this point. The next bill to be heard is House Bill 379. And there are only two people who are signed up to testify on it. One of whom is the prime sponsor, Representative Dolan. This is a bill relative to electronic notice. And I note that there were 13 people who signed up in support and no one who signed up in opposition. And Representative Dolan, if you're available, you could introduce your bill. And I don't see Representative Dolan there. Representative McLean, would you like to introduce the bill for Representative Dolan?
Yes, thank you, Mr. Chair. For the record, my name is Representative McLean, representing Hillsborough District 44, and I would like to introduce House Bill 379, an act relative to electronic notice.
Thank you for your brief testimony. Also having signed up to speak was Natch Grays, and is he available?
Hello, Chairman, can you hear me?
You can.
My name is Nate Grays. I am with the New Hampshire Municipal Association. We are in support of HB 379. It's actually a policy bill for us. It is a rather lengthy bill that enacts a very simple change. It allows municipalities to provide electronic notice via posting on their website in lieu of newspaper notice for certain hearings. It follows last year's adoption of HB 1129, which allowed a planning board to post notice on proposed zoning ordinances on the website instead of in newspaper. The bill's rather lengthy because there are dozens of sections of the RSAs where newspaper notice is required for public hearings. In theory, the easiest approach would probably be to do a blanket amendment, but We identified two problems with that. First, there are a few situations where we didn't think that electronic notice would be appropriate at this time. And so a universal rule wouldn't work because you'd have to have exceptions. And secondly, in most cases, the notice requirements for the individual statutes also specify that there must be publication in the newspaper. So someone would have to be very familiar with the statutes and know that there was another place where there was a substitute that said you could post on the website. So in order to make it easier for everyone, unfortunately, the bill has to be somewhat lengthy to update all of the statutes individually. That's my concise summary. I did submit written testimony that is to that same effect, and I'm happy to take any questions on the bill.
Representative Sylvia.
Thank you, Mr. Chairman. I'll be brief, and thank you for taking my question. One of the ones that I notice is not there is county delegation notice. Was that left out for a particular reason?
It was not. We don't represent counties, so we would not have proposed any sort of changes to those. I'll note that not all newspaper notice requirements are listed. This is just a list of a large number of them. Unfortunately, in going through the statutes, it's so cumbersome that we thought that to make it reasonable for the committee to act on limiting the list to probably the most important ones this year, and then proposing another bill next session, et cetera, until we get them all down, seemed more appropriate.
Thank you.
Representative McLean.
Yeah. Thank you, Mr. Chair. Just super quick. Is the driver behind this more on the cost side, or more that you're finding it's a more effective way to reach people? Just trying to understand the driver behind it.
Really, it's a very effective way of reaching people. As I'm sure all of you know, many of your communities are using not only the websites for their municipalities, but they often have linked social media accounts that push out updates to board and chair meetings. So a lot of people are getting their news that way. But of course, there is a cost factor as well. Unfortunately, a large number of smaller newspapers throughout our state have closed, meaning that the newspapers of general circulation are larger ones like the Union Leader, and ads in those cost more. So there will be some cost savings, but I wouldn't know exact numbers, and that would depend on the individual community, I imagine.
Representative Di Lorenzo.
Thank you, Mr. Chair, and thank you for taking my question, Mr. Grace. How does this bill intersect with RSA 91A, the Right to Know bill?
Right. So RSA 91A2 requires posting in two public places for any notice of a meeting. One of those can be the municipality's website, and that's actually that was actually an amendment that occurred, I believe, in 2018 or 2019. How this would play out is that obviously you'd have to have two public places, and if there's also a newspaper requirement, you'd have to find two separate public places. So you'd have, the town hall and the library, the town hall and the post office, two physical locations plus the website for the municipality. And I do want to be clear that there is a provision in the law already that the municipality's website has to be a real website. It can't be, the community's Facebook page. It has to be someplace that's accessible to everyone who goes on the internet.
Thank you.
Representative Horgan.
Yes, thank you very much, Mr. Chair. Thank you very much, Mr. Graves. And I think we do need to update the law. Like I see, for example, we talk about newspaper statewide circulation. We really only have one, and even the Union Leader's probably not on the newsstands everywhere in the state. But my main question is with the newspaper, first of all, at least in theory, everybody gets it. Every copy of the newspaper is the same. So like the ad is the same, and also it's permanent. The Union Leader is even, archived online and on microfilm, which actually publisher alluded to in an unrelated bill the other day. So how do we do the electronic notice in such a way that it's definitely the same for everybody, that an aggrieved person can't argue that what different people are getting different versions of notice, and how do we ensure that it's permanent? Thank you.
So as far as it being the same for everyone, it would have to be, it would be on the municipality's webpage. And so on the front page, when you go to, Concord.gov or Manchester.gov or whatever your website is for your municipality, if you are posting notices on your front page, you should have either the notice itself or a link to direct people to where the calendar is. And then the calendar is going to be the same no matter how you're visiting that. I'm not aware of any current requirement that notices be preserved. That would be under RSA 33-A:3-A, which is the Municipal Records Retention Statute. I don't believe that there's a requirement that notices of meetings are archived. If that's something the committee wishes to require, then it could do so.
Okay.
Oh, thank you.
Any other questions? Seeing none, thank you for your testimony today.
Thank you.
Is there anyone else who wishes to testify on House Bill 379? If you do, raise your hand. See no other hands, and we'll close the hearing on House Bill 379. Move on to House Bill. Open the hearing on House Bill 597 FN relative to the expectation of privacy. Note that there are 8 people who have signed up to speak on this. Primary speaker is the primary sponsor is Representative Earth, and we'll call upon Representative Earth to provide his testimony. It's available. Go ahead, Representative Earth.
Thank you, Mr. Chairman, and honorable members of the committee. I'm Representative Keith Earth, Hillsborough District 2, representing the towns of Deering and Ware, sponsor of HB 597, and I'm speaking in support of that bill. HB 597 protects an individual's informational privacy from government intrusion. It bars state and local governments from accessing an individual's personal information, which he or she has provided to non-governmental third parties. In 2018, New Hampshire citizens passed the Right to Privacy Amendment to our Constitution, with 81% voting in favor. This amendment states, quote, "An individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent," end quote. HB 597 continues the process of defining this right in statute. This is the same bill that passed the House last year. It passed out of committee 14-5 and passed the House on a voice vote. The constraints of COVID prevented the Senate from considering it last year, and it was laid on the table. The bill clearly defines what constitutes personal information as it relates to this bill. It states the expectation of privacy that we have as it relates to our personal information that we give to companies we interact with in our daily lives. It provides no government employee, elected official, or government contractor shall acquire, collect, retain, or use personal information. HB 597 includes clear exceptions for emergencies, warrants and subpoenas, information required by law, or information that the individual agrees need not be subject to this privacy. As the Honorable Sandra Keynes wrote for the Judiciary Committee last year, quote, 2 years ago, the citizens voted overwhelmingly for a constitutional amendment to protect their privacy. This bill is a modest attempt to put some statutes in place to start the process. It does not cover everything, and future legislatures will certainly find more areas to cover. It does require warrants for governmental bodies before they snoop. However, it does allow for an emergency situation. Your personal information should remain private to the extent possible. End quote. The committee received a letter from the Government Affairs Coordinator of New Hampshire regarding the effective date of HB 597, and I defer to the judgment of the committee on this. Testifying at some point after me is the Honorable Neil Kirk, who authored the original bill that has been resubmitted this year. He is able to address the exceptions and compatibility with existing laws in greater detail. In the interest of your time, it might be best to address your questions to him as he can provide more in-depth responses. Thank you for your time, and if you do have questions for me, I will try to address them.
Okay, are there any questions for Representative Irv? Seeing none, thank you for your testimony today.
Thank you, Mr. Chair.
Next speaker will be former Representative Neil Kirk. Senator Helene.
Oh, okay. Good morning, Mr. Chairman.
Good morning.
It's good to see you.
Yes.
Good morning to you and to members of the committee. For the record, I'm Neil Kirk. I was a former representative, and I now live, as I have formerly, in Ware. I support this bill. I think it's a very important first step in implementing the constitutional privacy amendment that was recently passed by over 80% of the state's voters. This bill does two things. It establishes a right of privacy in personal information that's in the hands of third parties, non-government organizations. I'll talk to that in a minute. And it also says that the legislature, not government agencies, shall determine whether or not informational databases are created in the future. Those are two very important but very different things. As you know, as we go through life, we deal with all sorts of other agencies, internet service providers, credit card companies, banks, telephone companies, social network organizations, and we give them all sorts of information about ourselves to enroll, our names, our addresses, sometimes social security numbers, biometric identifiers, all sorts of things. At the moment, these are not protected, so that if a state agency or individual wishes to get this information and the private organization is willing to provide it, that person can get that information without a subpoena or without a warrant. If the agency, the organization, the private organization won't supply the information, the state official could get it today by going and getting a subpoena or a warrant. But the point is, he now can, or she can now get it just simply by asking for it. This bill would say no. If you want personal information about an individual and that personal information is held in private hands and you're a government official, then you either have to get a warrant or a subpoena, or it has to be an emergency or some other exception that's written into the bill. I think that's what people expect, that their government will not go about collecting this personal information about them unless the legislature has authorized it, or unless they get a judicial warrant or a subpoena. The second part of the bill is equally important. Right now, various agencies can create databases of personal information obtained legitimately and use it for whatever purposes they wish. This bill says no, that's a legislative decision. And there are some exceptions to this, of course, but it's a legislative decision. The legislature will determine what informational databases the state is going to create and state agencies will have to administer. That's the essence of the bill. As Representative Irf said, this was passed by the House last year and got hung up in the Senate due to COVID issues. I hope the committee will see the wisdom of its prior actions and vote the bill ought to pass. Thank you, Mr. Chairman. I'd be pleased to answer any questions that members may have.
Thank you, Representative Smith.
Thank you very much, Mr. Chairman. Representative Kirk, we've had a lot of testimony come in, and I wonder if the chair would permit me to ask just 3 questions. The first is, the Municipal Association claims that this bill's strict prohibition would inhibit the investigation of criminal offenses. Could you comment on that?
Yes, it doesn't. It would simply require that the law enforcement agency obtain a subpoena or a warrant in order to get this information. It would prevent them from getting it, as they can now, from simply asking.
Well, thank you. May I follow up, Mr. Chair?
May.
Thank you. The New Hampshire Municipal Association says that ambiguous language and strict liability requirement could result in municipalities facing significant penalties for unknowing or unintentional violations. Could you comment on that?
First of all, I think I have more faith than Mr. Johnston in municipal officials in the sense that they are quite careful and cautious and follow the rules. But beyond that, the penalty here is for violating a provision of this, and that requires intent because it's a criminal act. So they have to do something intentionally. I don't think there would be a penalty if inadvertence was the reason for their action. Now, inadvertence doesn't mean carelessness and sloppiness. It means the inability that they just didn't know, they read the law and they just didn't understand it and didn't know.
And if I could have just one more, this would be my last, Mr. Chair.
That would be fine, Representative Smith.
Thank you, Mr. Chair. The banking department says that the language on page 2, line 17, appears to be intended to allow state agencies to do their jobs, but this language would not authorize the department to obtain information in examination unless it was requested with respect to a particular individual, so that the amendment or this bill would not permit the banking department to perform its statutory duties in examinations of financial institutions that might be a random examination. Could you comment on that?
Yes, I thought that those issues in particular had been addressed in one or both of paragraph 507H:2, 2B and 2C. I'm sorry, I can't give you the line numbers because the copy of the bill that's available on the internet does not have line numbers on it. B says, subparagraph A, that's the paragraph that says there's a right to privacy and it requires a warrant, says subparagraph A shall not apply to affinity type programs, which is not the issue here, but B says, I apologize, Mr. Chairman, I read the wrong section. B says subparagraph A shall not apply to personal information if it's authorized. No, wait a second. I apologize, I'm reading the wrong section. Here, it's Roman 4. 507H:2, Roman 4. This chapter shall not apply to personal information required, collected, retained, or used by any state regulatory agency, that's the banking department, with respect to a particular individual when such acquisition, collection, retention, or use is within the agency's regulatory, adjudicatory, or administrative function. If that was intended to deal with the situation that I think you described, Representative Smith, but if it is not, then perhaps some language, and I'd be happy to try to draft it in conjunction with Commissioner Little. This was designed to solve that problem. The idea of this paragraph 4 was to make sure that regulatory agencies could continue to collect this information if it was in their regulatory purview. And certainly the kind of activity that was described by Representative Smith is within the purview of the banking department.
Thank you very much for that. I will just point out that that is the exact language that the banking department is challenging. So it might be if you could come up with something that helps to satisfy the banking department, since we thought it had been addressed, that would be helpful. Thank you very much for indulging me, Mr. Chairman.
I will make that effort, Representative Smith.
Representative Birch, you have a question?
No, I was simply going to point out that what Representative Smith just pointed out, that the language in that section referring to an individual is what the banking commissioner was having problems with. So no additional question.
Are there any other questions for Representative Kirk? Yes, Representative Langley.
Representative Kirk, I'm looking at number 5, Roman numeral 5, and it says any person violating the provisions of this section shall be guilty of a violation if a natural person, or guilty of a misdemeanor if any other person. How would I have any idea or determine that my rights had been violated under this provision? I'm having a hard time understanding how the consumer would know that their rights have been violated. I guess.
Section 5, Representative Langley, deals with a criminal prosecution. A violation is a criminal act. A misdemeanor is a punishment for a criminal act. So the individual would not be prosecuting in that case. However, Section 6 is perhaps the one you're referring to. A person who suffers injury can sue. That's always a problem in these situations. The bill does nothing to help an individual determine whether his or her rights have been violated. And I share your concern. I'm not aware of a method to address that issue, but certainly if you found out that your name was included in a database, and the database, for example, had not been authorized by the legislature, or if, for example, you were involved in some sort of relationship with a state agency and they had information about you that you hadn't provided and you believed that they had gotten it elsewhere, you could inquire and ask how they got it, and that could form the basis for your suit. But to be very frank, that's a difficult situation. Much of the legislation we pass, how does one learn that his rights have been violated? I'm sorry, I don't have a better answer.
Thank you, Representative.
Any other questions? Representative Kirk, seeing none, thank you for your testimony today.
Thank you, Mr. Chairman.
We're behind schedule, so I'm going to ask everyone if they could keep their testimony to 3 minutes. It would be greatly appreciated. And well, since there have been inquiries in that regard, I'll call upon Kiara Dulcino, Attorney Dulcino, I think, to speak next. She's from the banking department.
Hi, my name is Kiara Dolcino. I'm the general counsel at the New Hampshire Banking Department. And as you heard, the concern that the department has, and we have presented testimony, Commissioner Little has testimony that he's presented for you. Unfortunately, he can't be here today. The concern is with the provisions in section 4, Roman 4 in proposed 507-H:2. That provision, we believe, was intended to permit regulatory agencies to engage in their usual practices of obtaining information from third-party providers. However, the language in that provision that references a particular individual is a concern, because we often in our examinations and in other work do not request information about a particular individual. We, for example, would do an examination and request from a bank or other financial institution information about, say, a period of time, how many loans give us all the loans you've done within this time frame. We have no idea who the consumers are for the information we're obtaining. We would have no way of having those names before we ask for the information. So our concern is that that provision would not allow us to do our usual work in examining banks and other financial institutions. The same would apply if we're investigating wrongful conduct. We would ask the institution, please provide us with the names of all and the information about all consumers who might have been impacted. Again, we don't know in advance the names of the consumers, so we're not asking for information about a particular individual. So those are our concerns, and I'm happy to answer any questions.
Are there any questions for Attorney Dulcino? Seeing none, thank you for your testimony today.
Thank you.
And Greg Moore.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Greg Moore, and I am the State Director with Americans for Prosperity, New Hampshire, and I am testifying today in support of House Bill 597. AFP supports House Bill 597, which protects the privacy rights of New Hampshire citizens. The legislation outlines several categories of personal information that individuals would retain a privacy interest in, even when that information is given to a third party. This bill really helps to put meat on the bones of the new Part 1, Article 2B, which explicitly codifies the right to privacy in New Hampshire's Constitution. Veteran members of this committee may remember that AFP supported CACR 16, which moved through House Judiciary in 2018 and eventually became Part 1, Article 2B. This legislation begins to put in place parameters for that amendment without waiting years for the courts to develop case law. As far as the specifics of the bill, in order to benefit from technology like social media and email, we give information to private entities constantly. In 1979, the US Supreme Court held that Americans had no privacy interest in information that they voluntarily gave to private companies. Thus, the numbers you call on your cell phone, your internet search history, and much more information that regularly passes through cell phone providers and internet service providers can be given to the state government or local governments without any judicial oversight. The expectations of privacy Americans have in their data no longer matches today's legal reality. House Bill 597 changes that by adding a warrant or subpoena requirement for personal information that we should all have an interest in protecting. This will clarify privacy protections for both law enforcement and the public in a constructive way, consistent with our state's constitution. The Supreme Court, US Supreme Court, has started to slowly update Fourth Amendment jurisprudence to reflect the norms of our increasingly digital society. But we need not wait for the federal courts to inch towards updating the Fourth Amendment. As Justice Alito said in the Riley versus California case, quote, it would be very unfortunate if privacy protections in the 21st century were left primarily to the courts using the blunt instrument of the Fourth Amendment. Legislatures elected by the majority are in a better position than we are to assess and respond to changes that have already occurred and those that most likely will take place in the future, close quote. We think that House Bill 597 is a statutory scalpel, molding the privacy protections of people in the state in a valuable way. It recognizes the role the legislature has in creating privacy protections. It would also work in tandem with the new constitutional amendment to clarify how it would work in practice. For those reasons, we support House Bill 597 and urge the committee to find it ought to pass. I'd be happy to take any questions, but I'd like to add that also joining us today, although not signed up to speak, is Billy Easley. Billy is the senior policy analyst and attorney who handles technology and innovation. He's available to answer any technical questions the committee might have. While I dabble in this issue, he lives in this world. So I'd be happy to volunteer Billy, who's on the line as well. So thank you so much, and I'd be happy to take any questions from the committee.
Are there any questions for Mr. Moore? Seeing none, thank you for your testimony today. And the next person is Kyle Baker.
Hello, can you hear me okay?
Yeah.
Thank you. Good morning. My name is Kyle Baker, and I'm with the firm Rathyoung and Pignatelli, and I'm here on behalf of the Internet Coalition in opposition to House Bill 597. I'll be very brief. We have submitted some written testimony that goes in depth into our concerns. And we just wanted to highlight a couple of key points and some real world examples where we think this legislation may have some unintended consequences. Our members are keenly aware of our customers' expectations and rights of privacy, particularly when it comes to their personal information. Digital privacy is the focus of considerable attention at the federal level, which is where we believe data security laws are best addressed. Technology does not stop at the state border, and a patchwork of state laws will only lead to a confusing and burdensome process for both providers and consumers. Two quick real world examples that we thought would be helpful in highlighting some of our concerns. This legislation would forbid government agencies from acquiring, retaining, obtaining, or even using an address, telephone number, or email address of any person, even for basic benign functions such as marketing or promotion of things that state agencies are doing. An example could be that the State Parks Division wanted to promote changes at one of its parks or send out an update of new park hours. Section 2 of this bill would specifically prohibit them from using any contact info, whether it's a physical address, email address, or phone number, to inform the public unless someone had specifically reached out to the department looking for this information. A second concern and example that we wanted to provide is around the use of mailing lists, whether it's for online charity fundraisers, political campaigning. Section 3 of this bill would specifically prohibit government contractors or elected officials from maintaining any sort of personal information in a database that wasn't specifically authorized by the legislature. So with that, will wrap up and refer to our written testimony and just say that the protection of personal information continues to be of utmost concern to the Internet Coalition and its members. However, we believe that this bill would do more harm than good. It raises issues of compliance for multi-state national businesses, but equally important in its simplicity, raises issues of adequate protection for consumers. And we would therefore ask you to oppose this bill. Thank you for your time.
Thank you. Are there any questions for Mr. Baker? Seeing none, thank you for your testimony. Next person would be Kathy Stacy.
Good morning, Mr. Chairman. Can you hear me?
Good.
Yes, thank you. I'm Kathy Stacy. I'm the Rockingham County Register of Deeds, and I am testifying neither in support nor in opposition. However, we do, as the Registries of Deeds, do have obviously grantor-grantee indexes that are available to the public and third-party vendors and everybody else. We're concerned about this bill to make sure that we are exempt from the obviously the violation of what these provisions are, to make sure that we are absolutely covered. Because as you know, you can go online to basically all 10 counties and do whatever research you wish. And we have names, we have addresses, that our index is by name only, but it's a guide to the documents, and you can look at documents and you can get information about banking, and you can get information about addresses and so forth. So we're concerned, obviously, to make sure what type of liability this type of bill is going to cause the counties. So that's pretty much my testimony, and I will take any questions.
Thank you very much for your testimony. And are there any questions? Stacy, seeing none, thank you very much.
Thank you very much. Have a nice day.
Natch Grays.
Thank you, Mr. Chair. I'm Nate Grays with the New Hampshire Municipal Association. Obviously, from Representative Smith's comments earlier, you've received our written testimony. We do oppose this bill. We are concerned about the ambiguous language. We do, to the extent that I can respond to Mr. Kirk's remarks earlier, we are concerned that the way this bill is written, that there would be strict liability, so that if there was a violation, whether or not intentional, that would result in liability attaching to the government agency particularly for us municipalities, and therefore there would be unintentional consequences, and those are outlined in my written testimony. I'm more than happy to take questions since I am trying to keep in mind how late the committee is running.
Thank you very much. Are there any questions for Attorney Graves? Seeing none, thank you again. The last person who pre-registered to testify is Maya McKenzie.
Thank you, Mr. Chairman. My name is Maya McKenzie, and I'm representing the State Privacy and Security Coalition. I am respectfully testifying in opposition to HB 597. We've submitted written testimony, but I'd like to highlight just a couple of ambiguities in light of our time. The first is that this bill would create a very ambiguous right, expectation of privacy and personal information, but there is great uncertainty around the information to which this new right would apply. The bill applies to personal information, content, and usage. However, content and usage are undefined, leaving both individuals and disclosing entities alike without clarity on what information is covered by this proposed expectation of privacy. Second, this bill does not appropriately consider the degree to which federal law intersects and protects many types of information that are described in the bill, such as health information through HIPAA, financial information with the Gramm-Leach-Bliley Act, and others. The private right of action that allows individuals to sue for statutory damages if there has been a violation for this vague and overbroad provision would lead to a surge in class action litigation, which rarely results in recovery for plaintiffs in privacy-related claims. But more importantly, this frustrates public safety efforts. First, the exception to the private right of action, which applies to corporations, would not apply to disclosures to county agencies. So disclosures to county agencies such as the sheriff or a nursing home would result in a potential $1,000 per violation penalty plus attorney's fees. Second, this exception only applies to corporations exposing non-corporate entities to class action risk. So organizations and public charities like New Hampshire's Children Trust, which advocates for child protection, should have the ability to make disclosures that support the public good without the threat of diverting resources and funds to defend against litigation. In this earlier testimony, the sponsor stated there would be no litigation risk for inadvertent or unintentional disclosures in violation of the bill. However, there is no such language in this bill that would provide clarity on that issue. So for these reasons, we oppose respectfully House Bill 597 and ask that you not move forward. Thank you in advance for your consideration on these matters, and please do not hesitate to reach out with any questions.
Thank you for your testimony. Is there any questions, Ms. McKenzie? Seeing none, thank you for your testimony. That concludes the list of pre-registered. There are a couple of people who do have their hands up who wish to testify. The first appears to be Representative Yokella.
Thank you, Mr. Chairman and members of the committee. Excuse me. I thank you for entertaining my testimony in opposition of HB 597 in its current form. Protections of unreasonable search and seizures have been eroded over ever since the electronic age started, and that's because there are not clear protections and safeguards in law. Snowden revealed that there were secret decisions that collection of personal information didn't constitute a search until they actually ran a search on the information that was collected. And there, I thank Representative Langley for bringing up the issue that we, as individuals, often don't know that our rights have been violated. I believe it was Representative Langley that mentioned that. And this information really needs to be kept private, and the search warrant needs to be presented to the the individual whose records are trying to be searched, so that they have an opportunity to challenge the reasonableness of the request. And so I think that there's a significant potential for erosion of people's privacy rights if this bill was to pass in its current form. There's currently already a statute, 644A, that addresses the protection of people's location data, and it does not seem that these protections listed in this bill, HB 597, reflect the wise decision of the State House and to put those protections in law. And this would actually open up what is currently not allowed to be shared, because this bill has far more exceptions than is currently allowed in 644A, specifically the subpoena requirement, which only has a level of requirement that the request is not unreasonable, oppressive, and excessive in scope, whereas the search warrant requirement requires probable cause and particularized suspicion. Also, 644A expands on the 911 exception and flushes it out so that instead of using vague language, it actually is clear on what is allowed and what is not. Also, 644A addresses the emergency exception. In this bill, it currently just says an emergency, and 644A flushes that out to what does that actually mean. And so there's also a broad exception for regulatory agencies, which has been hammered home, I think, by previous testimony as being an issue. Conclusion, I think that we need to really address this issue in conjunction with and informed by 644A and the protection that offers, especially because it talks about in this bill the location data also being protected. And so it would be two statutes addressing the same issue with two different levels of protection. So I'm happy to work with this committee on this bill and the sponsors, and I hope that the committee would retain this and we can work over the summer with the different stakeholders. And I'm happy to take any questions. Thank you.
Do you have any questions for Representative Ocala? Seeing none, thank you for your testimony today. Thank you for your patience.
Absolutely. Thank you.
Okay. And the next person is Attorney Richard Head. We're running way behind, so if you could try to make your testimony as succinct as possible, it would be greatly appreciated.
Great. Thank you, Mr. Chairman. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I just wanted to point to a written correspondence I had previously filed relative to the effective date. I think this bill triggers RSA 14:9-A, which would require that the effective date be January 1, 2022 instead of upon passage if this were to go forward. And that's basically to allow the judicial branch the opportunity to, with the hundreds of changes that are made, to update our database systems, to ensure that notice has gone out to all law enforcement regarding changes on criminal code. And this includes a provision that has criminal penalties. Secondly, which is not contained in my letter, I note that on page 2, where they have the exceptions, it refers to state agencies or state departments and agencies that receive information as part of their normal duties. The judicial branch is probably not a state agency or department, and probably should be included within that list as receiving on a regular basis through pleadings and filings information that would be considered confidential or personal information. With that, I'd be happy to answer any questions. Thank you very much for your time today.
Thank you for your succinct testimony. Any questions for Attorney Head? Seeing none, thank you.
Thank you.
There's one remaining hand up, and then we'll close the hearing. That's Chris Gilrain.
Thank you so much, Mr. Chairman, and I will be very brief. I represent TechNet. We are a national organization of companies throughout the innovation economy. Just wanted to bring up one particular point of concern for our members. It's unclear under the legislation whether companies, when being requested information by the state agencies, should refuse access or seek legal counsel as to whether the request falls under the agency's purview and therefore be allowed under Roman numeral 4. Essentially concerned that this puts them in a situation where they have to choose between failing to comply with a state request or risk litigation for complying. That compounded with the private right of action and that makes the unclarity here particularly concerning. Again, thank you very much for your indulgence. We did submit written testimony as well.
Thank you very much. Are there any questions for Mr. Gilrain? Seeing none, thank you very much.
Mr. Chair, the blue sheet.
Yes. Although it's not blue.
Well, imagine that it is.
There are 8 in support, or registered in support, 7 registered in opposition.
Thank you.
1 neutral, which was the register of deeds. So we'll close the hearing on House Bill 297, which brings us to our last hearing of the morning. I'd like to take a break, but since there are people who appeared here to testify and they've been waiting a half an hour, I just as soon go ahead with the hearing if we can and get it done. Limit the testimony if I can, as best I can, to a couple of minutes for each person. This is, so we'll open the hearing on House Bill 288. I'm going to note that there are 6 people who registered in advance in support and 48 people who registered in opposition. And with regard to the people who registered to testify, 11 people registered to testify, and every single one of them registered in opposition to the bill. So the bill is, the primary sponsor of the bill is Representative Bass. And if he is available, we'll call upon him to introduce the bill. Let's see.
Mr. Chair, if I could, the prime sponsor, Representative Abbas, told me that Representative Roy would be prepared to introduce this.
Okay, thanks, Representative Roy.
Hello, can you hear me?
Yes, we can.
Oh, great, thank you. Good morning, Mr. Chairman, members of the committee. I appreciate you hearing the testimony to open this bill this morning. For the record, my name is Representative Terry Roy. I represent Rockingham District 32. Chairman Abbas grabbed me this morning on my way to the gym, so pardon me if I seem a little unprepared for this. He got called away to an emergency meeting he could not get out of. So this bill, HB 288, repeals RSA 679, the Housing Appeals Board. The Housing Appeal Board was presented on its merits last year, and it failed to gain any ground. The policy was passed eventually because it was included in the budget, and to avoid a government shutdown, the budget was voted for and it was included and passed. Barring some change in circumstances, the governor has represented that he would sign a bill that would change this, and if it made it to his desk. Eliminating this board would save New Hampshire taxpayers nearly $500,000 per year. Overwhelmingly, the majority of support for the Housing Appeal Board came from real estate developers. However, these developers created a board that follows nearly the same procedures as the appeal process if it were filed in Superior Court. One particular concerning section of the Housing Appeals Board statute, RSA 679:7, Roman 2, The prime sponsor believes that this would allow for land developers who has standing to transfer a petition previously filed in the Superior Court to the Housing Appeal Board over the objection of the petitioner who filed in Superior Court, provided the land developer has standing. We do not need this board at the state level making decisions undermining local control of our communities. And that's the introduction for the bill. Representative Abbas has told me that he intends to be here before the end of this hearing to take questions.
Thank you very much for your testimony today.
Thank you, Mr. Chairman.
Do any of the committee members have questions for Representative Roy? Seeing none, again, thank you. Call upon Senator Bob Guida, if he's available. Did you? Oh, there he is. Yep, Bob Guida.
Good morning, Mr. Chairman and members of the committee. For the record, Bob Guida, State Senator, District 2. If you will, the originator of the Housing Appeals Board. Ladies and gentlemen of the committee, we exist to solve problems in our state. Right now, we have a vacancy rate of 1%. And people literally, for example, on the headlines in the Concord Monitor this morning, being thrown out of their houses so that rents can be raised. Certainly appropriate. The problem is we have no inventory. That is the result of a number of problems systemically over the years, not the least of which has been the time it takes for developers to get their projects through the system. They go to a series of meetings with respective land use boards in the community. And if the land use board declines to permit the project, then what happens is it goes to Superior Court if the developer chooses to go. This is a process that's expensive, time-consuming, and very frequently results in the erosion of financial support necessary to fund these projects. Bear in mind, this is not about Section 8 housing. This is about workforce housing. And serving on Finance and Ways and Means in the Senate for now my 5th year, I can tell you that more than a few companies that have looked to come here, good companies, have declined to do so because we have no housing stock. Part of the problem for that is, part of the reason for that is that we've not been able to build because much of our projects are tied up in courts that take time, energy, and material. This bill in no way allows contrary to the remarks of the previous speaker, allows someone to jump back and forth between the courts and the Housing Appeals Board. It's very explicitly stated in the legislation. A person gets to choose one or the other. And if they choose the one, then any action in the other is stayed, and the process moves forward. What's important in this panel is that it has 180 days to arrive at a decision. It does not override decisions of planning boards. It does not establish new laws. It just merely makes certain that planning boards and land use boards abide by state laws on workforce housing and abide by their own ordinances. In more than a few instances, this has not been the case. So this board now has 2 cases before it. I invite you to review the letters submitted by the newly appointed chair of the Housing Appeals Board, and having now been started and already seeing processes moving forward that will significantly expedite the construction of housing by resolving these differences between planning boards and developers without having to resort to the court system. I would ask that you support the Housing Appeals Board and vote in opposition to House Bill 288, and I'll take any questions.
Any questions for Senator Guida? Seeing no questions, thank you for your testimony today.
Thank you, Mr. President, Mr. Chairman.
And call upon Elliot Berry.
I'm sorry, can you hear me?
Yeah.
Okay, great. Thank you. Mr. Chairman, I'm Elliot Berry. I'm the Director of Housing Justice for New Hampshire Legal Assistance, where I've been practicing law as it relates to housing in almost every aspect for about 44 years. I just want to be really quick about this. First of all, I think a lot of the opponents assume that this board is going to be extremely friendly to developers. What I would suggest is that, look, you have the 3 members are appointed by the Supreme Court, who, as far as I know, has never had an anti-local bias. And then the other member by statute is a land surveyor or an engineer. I think they're applying the same law that the Superior Court would apply. And I think the only reason that more housing will be developed from this is that projects will not go under because of the time and expense of Superior Court litigation. And there's no reason that development should not happen because of the delays and expense of litigation. Thanks to the Housing Appeals Board legislation, people will not have to hire lawyers. Decisions will generally be made within a 6-month period. The rules of evidence won't apply. And in fact, you probably have more expertise on the board than you would in Superior Court, because the statute says that all these people have to be experienced in land use development or housing development. A great majority, I think, of the Superior Court are people who are former attorneys general, who have no reason to believe they have any background in local land use law. So the bottom line, I mean, the other thing that just makes sense is that this board has been up and running for about a month, maybe a month and a half. You know, I would urge you at very least to just wait and see how it works. I think it's going to work every bit as well as the Board of Land and Tax Appeals on which it's based. But let's wait and see. And the proof of the pudding, they say, is in the pie, or whatever they say. So I just urge you to vote ITL on this legislation.
Thank you. Are there any questions for Attorney Berry? Seeing none, thank you again for your testimony. David Juve.
Yes, Mr. Chair, members of the committee, can you hear me okay?
I can hear you fine.
Thank you. For the record, my name is Dave Juve. I'm a Senior Vice President with the Business and Industry Association. We're here in strong opposition to this bill. Establishing the Housing Appeals Board was a top priority for the BIA, and we remain in favor of that board, with Attorney Berry just noted, has barely been up and running a month. We think that it will actually save the state money, not cost the state money, by providing a more expeditious and inexpensive way to resolve a dispute between housing developers and municipalities. The reality is employers around the state are having a great deal of difficulty attracting employees with the limited amount of housing stock available for those employees. We are fully supportive of the Housing Appeals Board. We do think it will work to help increase workforce housing throughout the state, and we would urge you to reject this bill. I'd be happy to address any questions.
Thank you. Are there any questions? Yes, Representative Macbeth.
Thank you, Mr. Chair. And thank you, Mr. Gervais, for taking my question. Just from the past 2 witnesses, we've heard that, it's consumers, testimony that consumers would not benefit. You're saying that, employers would not benefit. Who is going to benefit if this bill is repealed? I mean, if this
frankly, Representative, I don't think anyone benefits. I don't think the municipalities benefit, because just if you repeal this board, that doesn't mean these disputes are going to go away. It means they're going to have to be decided upon in court, which is expensive both for the developer and for the municipality, not to mention the fact that one of the greatest advantages of this Housing Appeals Board was that it can act expeditiously on these disputes and resolve them and not have it dragged on for months and years through the court system.
Thank you for answering that question, and thank you, Mr. Chairman.
Any other questions for Mr. Dubay? Seeing none, thank you for your testimony today.
Thank you, Mr. Chair.
Again, I'm just going to add that everybody who signed up to testify has signed up in opposition. So hopefully if they testify, they can be succinct and just add new information that might be helpful to us. The next person would be Gregory Michael.
Can you hear me now?
We can hear you.
Thank you. Good morning, Mr. Chairman and members. My name is Gregory Michael. I happen to be the chair of the Housing Appeals Board. I was placed on the board by the Supreme Court and confirmed by the governor, along with Elizabeth Fisher, and we're still waiting our third member. But in the interim, we're able to have surveyors and engineers who are selected and approved by the Supreme Court to sit on an as-needed basis. We've only started in mid-January. We have 2 cases filed, and I will tell you that our first trial is April 7th. I think any of you who are familiar with the court system would recognize that that's, quote, moving the ball down the court fairly rapidly. Our purpose is to do what you've heard, and that is to expeditiously, fairly, and responsibly handle these cases. I've submitted a letter to the board. I would encourage the members to read it. I should say the committee to read it. I think it outlines some of the thoughts that we have in analyzing RSA 679. The bottom line is, as noted, we believe that it's important to keep the projects moving in the sense that if it's denied at the local level, we can take a look at it quickly and make decisions that are fair and appropriate. And I would point out, based upon the local regulations and ordinances. I want to make it crystal clear that I've heard rumors that somehow we're some regulatory change agent. We are not. We operate like the Superior Court, only more quickly and with board members that have significant expertise. I've been involved in land use and planning for over 40 years. I've experienced every aspect of it. Our real estate person, Beth Fisher, has been involved in real estate matters for over 40 years. And any of the surveyors and engineers that we select and use are also experienced people. The list of names that I've submitted to the Supreme Court to consider on a temporary basis, I've known them all for more than 30 years. These are people, I would like to suggest, will have the ability to quickly, promptly, and fairly review these matters. And I would point out that this goes both ways. I mean, for the municipalities, when they approve a project and it's appealed by abutters, it's important that it get resolved. Likewise, if the town or city denies a project and there's an issue with it, we're going to take a close look. And if there's a problem, we can get the project back on track. And this is really the fundamental difference between us and the Superior Court. We're trying to do it quickly, with expertise, and as pointed out at a much less expense than chasing your tail in Superior Court for potentially a year or more dealing with these cases. That's the summary of my remarks. I don't want to take up more time. I know your time is limited today. I appreciate you hearing me out. If you have questions, I'll be happy to answer them.
Representative Macbeth, did you have a question? No?
Thank you. I just didn't lower my hand. Thank you so much, Mr. Chairman.
Representative DiLorenzo.
Thank you, Mr. Chair. And thank you for taking my question, Mr. Michael. Opponents of this legislation say that the Housing Appeals Board takes away local control. What would you say to that?
I would say that's absolutely a false statement. We do not take away local control. We are a different appeal place to go. You either come to us or the Superior Court. And I'll point out, and I agree with, I believe, Senator Babbitt that testified, there's no right to bounce back and forth. You make an election to come before us or make an election to go before the Superior Court. And we do not change local laws. We do not change local ordinances. We operate under the legislative scheme in each town and municipality, which is done now. Our review is the certified record of what the local town board experienced. We don't take additional evidence unless it's critically important. We operate on the certified record, and we do not change, modify, or add to local zoning or planning regulations. Those are left to the local municipalities as provided by state statute.
Thank you.
Any other questions for Ms. Michael?
Yeah.
Yes, Representative McLean.
Thank you. Just a quick question. The co-sponsor of the bill said that the case could be moved from one venue to another against a petitioner's will, but who gets to choose the original venue? Do both parties have to agree to the original venue, or how is that arrived at?
It's arrived at the petitioner, the person who's bringing the appeal, selects the forum. No different than now. If you have a case that could be heard by the circuit court, it can be in the circuit court. That same case, depending on the jurisdictional limits, might be heard in superior court. So it's the petitioner, the person appealing, selects the location. I would point out that either party could make a motion before us, I suppose, or before the superior court to move it back and forth. That's going to require the consent of both parties before that happens. So to answer your question, it's the petitioner that selects the trial location.
Representative Alexander.
Thank you, Mr. Chair. In your opinion, Mr. Michael, is a ruling by the Housing Appeals Board have the same kind of precedent or case law established?
Well, I would point out that the Housing Appeals Board and Superior Court are not considered courts of record for judicial opinions. That's the state Supreme Court. Our orders have the equivalent force and power of a Superior Court order. I would like to make that clear. We have the powers of a Superior Court judge to rule and handle these cases. So our orders are equivalent to Superior Court orders. And to the extent that people would like to review our orders, they certainly can, but each case would be decided on its own merits based upon the facts and the law of each municipality. And that's the same standard used by Superior Court.
Are there any other questions for Attorney Michael? Seeing none, thank you for your testimony today.
Thank you, Mr. Chair and members.
Yeah. Ben Frost. Oops.
Good afternoon, Mr. Chairman. Thank you. And good afternoon, committee members. My name is Ben Frost. I'm the Managing Director for Policy and Public Affairs for the New Hampshire Housing Finance Authority. And I'm before you this afternoon to express New Hampshire Housing's opposition to House Bill 288. And I'll direct you to the letter that we submitted from our Executive Director, Dean Christen. Which, and I'm not going to go into the details of that letter. You're free to read that on your own. And most of what I wanted to say has already been said, so I won't repeat it. So I'll be even briefer than I intended. But I do want to point out that the Housing Appeals Board was based on the structure and longstanding performance of the New Hampshire Board of Tax and Land Appeals, which has since 1973 admirably served the state of New Hampshire and its citizens. The Housing Appeals Board is not a political body, given that its members are appointed by the Supreme Court and it's not subject to political influence, which I think is a good design measure. And emphasizing what Chair Michael just said about the issues of fairness, the Housing Appeals Board was really designed to be fair to all parties involved. As a housing advocate, I probably would have preferred a Housing Appeals Board to which only developers could appeal, but that would not have been fair. And I think the legislature recognized that and adopted legislation that created a board, that established a board that is fair to developers, to property owners, to abutters, anyone else who can demonstrate standing in an appeal, and yes, to municipalities. For the foregoing reasons and for reasons that others have stated, as well as the letter from New Hampshire Housing, we respectfully request you to ITL House Bill 288, and I'd be happy to take any questions.
Thank you for your testimony. Are there any questions for Mr. Frost? Seeing none, again, thank you. Next person will be Chris Norwood.
Good afternoon, Mr. Chair, members of the committee. My name is Chris Norwood. I am the Public Policy Chair for the New Hampshire Association of Realtors, and I come before you today to request you to ITL this bill like others have before. And I will be brief, just limiting to some new text as you had requested, Mr. Chair. Statistically, rents in the last 5 years are up 22%, according to the New Hampshire Housing Finance Authority. And according to our statistics as the realtors, the median price of a single family home is up 37% in those same 5 years. The balance of the data I just want to give, there was a question as far as the costs in raising. This is going to raise fees for the state. We believe it's going to be a less expensive path forward for both cities and towns and also aggrieved parties, which is really the last thing I'll say, echoing what Ben just mentioned, is that we are for property owners. Yes, we would like to see more housing. That is an important challenge that our state is facing together, but we can't do it on the backs of abutting property owners. And if you are an aggrieved abutter, you could have standing. I'm not going to get into the details of who has standing in an appeals, but we feel that this is a good path of remedy for all parties who may have concerns, be it a developer or another party of standing who wishes to challenge that development. So with that, I will entertain any questions and thank you for your time.
Any questions for Mr. Norwood? Seeing none, thank you for your testimony today.
Thank you.
Next person is Elisa Margolin.
Thank you, Mr. Chairman. For the record, my name is Alyssa Margolin. I serve as Director of Housing Action New Hampshire. We're a statewide coalition of 80 organizations united around affordable housing policy and ending homelessness in New Hampshire. We are opposed to House Bill 288 and to just provide new information per your request, Mr. Chairman. Housing Action New Hampshire was one of several stakeholders who have been working on this proposal for several years. For our members include those who develop, finance, and manage affordable housing around the state of New Hampshire. We're expressing concerns about delay tactics that were driving up the cost of providing housing as mission-oriented developers who want to pass on a more affordable property to those seeking a home that they can afford. Adding the delays and costs associated with the traditional review process is not an option for our developers, as they cannot pass along those additional costs to their consumers. So there was this absence of justice. In fact, they just, in many cases, did not appeal. I'd also like to make the point that the Housing Appeals Board does not in any way mean that that those reviews will be in favor of the developer. As we have seen in the longstanding Bureau of Tax and Land Appeals, it is simply a more efficient and more effective appeal mechanism so that our judiciary can prioritize their caseload. And with that, I'll conclude my testimony.
Thank you. Are there any questions for Ms. Margolin? Seeing none, thank you for your testimony today. There are 4 people who pre-registered, still haven't spoken, who pre-registered, and the next person is Doug Marino.
Hi, can you hear me?
We can.
Hi, thank you so much, Mr. Chairman, and thank you, members of the committee. I'll be very brief because I know the committee's running behind, and much of what I said in my testimony has been said, and I submitted some written testimony as well. So all I'll say is my name's Doug Marino. I work for an organization called 603 Forward. We are a youth advocacy organization, and one of our priorities is to promote affordable housing in New Hampshire to help attract and retain more young people to our state. Repealing the Housing Appeals Board would be very detrimental to the goal of promoting affordable housing and attracting more young people to our state. We believe that the Housing Appeals Board has been a reasonable reform that helps expedite the process for appeals and helps pave the way for more affordable housing. So we strongly urge you to support an ITL recommendation for HB 288. And I'm very grateful for your time today. Thank you, Mr. Chairman.
Thank you for your brief testimony. Any questions for Mr. Marino? Seeing none, thank you. Jason Sorens.
Good afternoon, Mr. Chair, and thank you. My name is Jason Sorens of Amherst, New Hampshire, and I am also director of the Center for Ethics at St. Anselm College. And our center and I myself do a lot of housing policy research. And I'll stick to a couple of original points that previous speakers have not addressed. One is that economists have found that local regulatory barriers to building new homes is really the main reason why New Hampshire is facing a critical undersupply of housing. And those regulatory barriers are not just those codified in black and white on paper. In fact, to a substantial degree, they consist of the discretionary decisions of local land use boards. It's not unknown for a local land use board to take an illegal decision to block a potential development, perhaps because of the fears of abutters, or simply they don't like the project. And the developers, the property owners who are most deterred by challenging those sorts of decisions are the small landowners. Big developers may have legal departments or lawyers on retainer who can take these cases to court. But very often a smaller landowner, think of a farmer subdividing his property into a handful of single family home sites, may simply look at this barrier and say, no thanks, I'm not going to take the cost and the delay of pursuing this fight in the courts. The other point I would make is that the Housing Appeals Board is actually fairly innovative. It fits a model of appeals boards that we have here in New Hampshire, but other states are also looking at our Housing Appeals Board specifically. I was invited recently to participate in a panel by the Manhattan Institute, which is the free market think tank in New York, on a paper that is on New Hampshire's Housing Appeals Board. And other land use scholars are looking at this as a model that other states could adopt to help make it so that we at least know that the regulatory barriers that are preventing new housing are the ones that are actually written down on paper. So this doesn't actually repeal any regulations, but it simply makes it so that those regulatory barriers that do exist are transparent. Thank you, and I'm happy to take any questions.
Thank you. Are there any questions for Mr. Sorens? Seeing none, thank you again. William Sturdivant. Maybe it's William Sturdivant North. You see it? Next one. Yeah, if you're out there, you need to raise your hand. Yep, there we go.
Yeah, I finally got the unmute thing. People hear me now?
We can.
Good, thank you. I appreciate the opportunity to express my feeling that this bill, HB 288, should not move forward. I am a business owner. I'm not part of a number of the important groups that were represented earlier. I run a business. I have 21 employees here in Portsmouth. I have 5 employees that are under the age of 35. Of those 5 employees, 1 lives in the state of New Hampshire. 2 live in Massachusetts and 2 live in Maine. That's all stemming from affordability. And frankly, if it hadn't been for a little bit of fortune, good fortune, I would have lost the employee that currently lives in New Hampshire. The housing shortage is a critical one for us business owners. It's a critical one for this the future of the economy of New Hampshire. Anything that helps address that problem is going to help the businesses and the citizens of our state. Business-friendly New Hampshire is a housing-friendly New Hampshire, and vice versa. I thank you very much.
Thank you for your testimony. Any questions for Mr. Sturtevant? Seeing none, again, thank you. And the final person who pre-registered to testify is Robert Turney. If you're out there, please raise your hand. There we go.
Hello, this is Robert Turney, and I'm the Executive Director at NeighborWorks Southern New Hampshire. And I think one of the unmentioned folks that will be impacted by this and hopefully benefit from this are homeowners. We're an affordable housing developer, but when the bill was introduced, the sponsor mentioned that it was going to benefit developers. And I think it's important to mention and recognize that single-family homeowners in municipalities often encounter many of the same challenges that developers do, and they certainly don't have the wherewithal to pursue a challenge through the court system. And I'd just like to give one example as an affordable housing developer of an example where I had a planning board chair look me straight in the eye and say, there's no conditions in our planning ordinance, that will require us to put these conditions on the approval of your project. But nonetheless, since it was brought up during the approval process, we're going to make you adhere to them. And I have to then take that recommendation and that decision and decide, do I want to move forward with my approvals and spend the extra $100,000 on our project that this is going to cost us? Or do I want to not accept it and go through the lengthy and expensive judicial process? And I had no choice. I felt like I had no choice because I could not afford the time delay that would be associated with a legal challenge. And so we agreed to accept the conditions and pay the $100,000 in additional construction costs that put on our project. Had something like the Land Use Appeals Board been in place at that point in time, I probably would have been able to come forth with a different decision and affect my project differently and had been so expensive. So I really want the committee members to take that into consideration and hope that you will ITL this bill. Thank you for hearing my points today.
Thank you, Mr. Turney. Any questions for Mr. Turney? Seeing none, thank you again. There are 2 other people who have raised their hands who wish to speak on this bill.
Natch Gray is also on the list.
Did I miss somebody?
Yeah. He was on the list requesting a 2-minute to testify. I didn't see that. Oh, sorry. I'm at the wrong bill.
Okay.
Mr. Attorney, turn off your sound.
Gary Pollock.
Can you hear me, Mr. Chairman?
We can.
Great. Good afternoon, Mr. Chairman, members of the committee. I'll be very brief. I'm Ari Pollock. I'm an attorney and lobbyist for the New Hampshire Home Builders Association. I've been a lobbyist and a land use attorney in New Hampshire for over 20 years. I just want to join the chorus as a longtime stakeholder and strong supporter of the Housing Appeals Board. We strongly oppose repeal and therefore oppose this bill. We ask that you ITL the bill. The Housing Appeals Board can only help and not hurt a state that's in the midst of a workforce housing crisis. And we appreciate the desire to be frugal with the taxpayers' money, which seems to be the motivation of the sponsor. But this expense is worthwhile. It's already part of the state budget. It addresses a priority item, and the Housing Appeals Board is just in its infancy. and should be given a chance to perform. Thank you very much for taking my testimony.
Thank you for your brief testimony. Any questions? Mr. Pollock? Attorney Pollock? Seeing none, thank you. There's somebody with their hand up that says stay, work, play, whoever that might be.
Thank you, Mr. Chairman. Can you hear me?
We can.
Excellent. Thank you, Mr. Chairman, members of the committee. My name is Will Stewart. I'm the Executive Director of Stay, Work, Play New Hampshire, excuse me, which is a statewide nonprofit whose mission is to attract and retain more young people here in the Granite State. And I'm here today to speak in opposition to House Bill 288. Others have spoken about the particulars of the Housing Appeals Board and why it's a good idea. I just want to speak for a minute about the need to do everything we can to make housing more affordable for young people and everyone here in New Hampshire, and not to make the housing affordability situation even worse. So attracting and retaining more young people is critical to the future of our state. New Hampshire, as you may know, is the second oldest state in the country with one of the lowest unemployment rates. On top of this, we're the #1 exporter of high school graduates seeking a 4-year degree, with some 62% of these young people leaving the state every year. Some of them come back, but a lot of them don't. In short, New Hampshire needs all the people we can get in general and all the young people we can get in particular. And our businesses, they need workers and customers, as we've heard. Our towns need volunteered board members, our nonprofits, our churches, our civic clubs, all need volunteers to accomplish their vital missions, without which our communities and our state just can't function. About 3 years ago, Stay, Work, Play commissioned a survey to collect data on why young people stay in and might leave New Hampshire. And the #1 reason we found that young people might leave is that they just can't afford to live here. Our housing, both on the rental side and on the home ownership side, is just too expensive. And we heard this over and over again last winter as we talked to young people in 9 locations across the state as part of our Policy and Pint series. So, housing here in New Hampshire is expensive for just about everyone, but it's especially expensive for young people who, by being early in their careers, generally make less money than their more experienced counterparts. And young people also face the additional burden of student loan debt. Indeed, New Hampshire has one of the highest average student debt loads in the country. And so, when you're paying hundreds of dollars a month in student loan payments every month, it makes it that much harder to afford housing that's already expensive. So, for these reasons, we ask you to oppose House Bill 288 and to retain the Housing Appeals Board, which will help to make housing less expensive here in New Hampshire. Thank you.
Thank you. Are there any questions? Seeing none, thank you for your testimony. Is there anyone else who wishes to testify? Seeing no hands, we will close the hearing on House Bill 288 FF, which brings us to the end of our morning docket. Yeah. I guess the question, Jen, if you're on the line, is it possible to put up a message that indicates that we would reconvene for our hearing on 478 at 1:15?
Yeah, we can do that.
Okay. Then I think that that's a good idea to give people enough time to take a little bit of break anyway. So if you would mind putting that message up, and we will recess our today's hearing until 1:15. Thank you, everybody. 478. Call this meeting of the House Judiciary Committee back to order. We are scheduled this afternoon to hear House Bill 478. This is relative to treatment of PFAS contaminants in the drinking water of the Merrimack Village Water District. Representative Maureen Mooney is the primary sponsor, and we'll call upon Representative Mooney to provide her testimony and introduce the bill.
Thank you very much, Mr. Chairman. Is everybody able to hear me?
We are.
Perfect. Well, for the record, my name is Maureen Mooney, a state representative for the town of Merrimack in Hillsborough County, District 21. I'm the prime sponsor of House Bill 478, an act relative to treatment of PFAS contaminants in the drinking water of the Merrimack Village Water District. I am in support of this bill. I just want to highlight for the committee that the co-sponsors on this bill represent a cross-section of legislators from both parties in leadership from across the state, as well as in Merrimack. And those of us in Merrimack behind the bill solidly could not be more pleased with the bipartisan collaboration and cooperation in efforts to pass House Bill 478. I just want you to be aware that there will be several testifying after me who bring to the table extraordinary technical and historic knowledge and expertise on this very vast issue. I'd also like to point out to the committee that last night I emailed to you my testimony. And what I did in that document is that I categorized my testimony into headings to try to make this as clear and concise as I can. So I'm going to start now with the background on this bill. The town of Merrimack has undergone what is considered the worst case of environmental pollution in the state's history. The town has spent years reacting to the effects of PFAS contaminants in clean air, drinking water, groundwater, wastewater, and soil. A detailed summation of that history starting in 2016 is found in this bill in section 1, Roman numerals I through 7, 1 through 7. To give some background on my involvement with this bill, the late Speaker Dick Hinch of Merrimack asked that I work with the Merrimack Citizens for Clean Water on 2 legislative initiatives this session. As a result, I am the prime sponsor of House Bill 478. Additionally, I know that members of the Merrimack Citizens for Clean Water will be testifying today in support. The next category of my testimony is a summary of the bill. In sum, the bill extends the operations and maintenance remedy in the March 2018 agreement between the Merrimack Village Water District and St. Gobain Performance Plastics for the Merrimack Village Water District wells number 4 and number 5. I have a reference there where it can be found in the bill if you have that in front of you and it's easier. That's in section 1, Roman 8. As it stands now and today, such operations and maintenance costs will be paid by St. Gobain only through 2025, representing the first 5 years of the water treatment system operation. House Bill 478 calls for St. Gobain to pay, and this is a quote from the bill, all costs associated with the continued operation, monitoring, and maintenance, and any necessary additional modifications thereto, and all additional incidental operation and maintenance costs of wells 4 and 5, beginning on October 27th, 2025, and continuing for so long as the Merrimack Village Water District treats water in wells 4 and 5 to comply with any existing or future water quality standards set for PFAS. And that can be found in the bill, section 2, Roman 2, line 3 on my version. It's important to note here that the October 2025 date is 5 years from the October 2020 activation of what is called a granular activated carbon filtration treatment system in wells 4 and 5. The next header on my testimony are the standards. As to the standards for keeping the wells, what is called online, House Bill 478 refers to the PFAS standards effective in July of 2020. And those standards can be found in RSA 485:16e. Again, this can all be found in my testimony. Additionally, House Bill 478 mentions in section 2, Roman 2, that remedial payments occur for so long as the Merrimack Village Water District treats water in wells 4 and 5 to comply with any existing or future water quality standards set for PFAS. Next category of my testimony is rationale, of which I have 3 points. Number 1, the town of Merrimack and surrounding area believe in holding pollutants accountable, and this bill will accomplish that. Number 2, the bill references an April 1st, 2016 letter from the Department of Environmental Services to St. Gobain, signed by the commissioner. In that letter, on page 3, the department formally requests St. Gobain to, quote, provide for the necessary long-term operation, maintenance, and monitoring of the installed treatment systems. This House bill will fulfill that Department of Environmental Services demand. My third point of rationale is that the town of Merrimack and or the Merrimack Village Water District cannot incur costs in perpetuity to filter polluted water from an industrial polluter. Although DES derives its authority to enforce its April 1st, 2016 letter from, and the citation there is RSA 485-3, DES has not taken enforcement action. This bill will directly place the costs of operations, monitoring, and maintenance on the polluter, as DES has intended in its April 1st, 2016 letter. The last and final category of my testimony is my conclusion. In conclusion, we, that is the town of Merrimack, ask that you not look at this bill through the lens of overregulation or state mandate. Rather, we ask that you envision the circumstance if this bill does not pass. If this bill does not pass, then at midnight on October 27, 2025, Merrimack citizens will be in the unprecedented position whereby MVD customers, that is Merrimack citizens, will be forced to bear the costs to pay for a private industry's cleanup while that industry is allowed to continue to pollute. This unfortunate scenario then results in an additional undue burden on Merrimack citizens, as well as a precedent where citizens are forced to pay through the Merrimack Village Water District to prevent private pollution. Simply a scenario and a precedent we cannot set. I would respectfully ask that the committee vote House Bill 478 ought to pass. And with that, I'm going to conclude my testimony. And I want to thank you once again for your attention and your service. Thank you, Mr. Chairman.
Thank you, Representative Mooney. And Representative Birch, do you have a question?
Yes, I do. And thank you, Mr. Chairman. And thank you, Representative Mooney, for taking my question. And it's kind of the overarching question about contracts and enforcement of settlement agreements and the like. As I understand it, there's been pollution in that area. It was believed that St. Gobain caused the pollution. St. Gobain says, no, we didn't do it, all the pollution or some of the pollution or whatever percentage may be. And eventually a settlement agreement was reached. Both sides got something out of this settlement agreement. The Merrimack got to avoid the litigation about who's liable for the damage, could go right into the solutions, save years of litigation costs and time, et cetera. And the St. Gobain got a defined obligation out of the situation. Am I correct in understanding that what you would like done is ripping up that agreement, but keeping the admission, so to speak, by St. Gobain of their liability, and just saying you guys are liable and you're just going to have to pay everything? Or do you envision going back to what the situation was before the agreement, which was to litigate in court all the issues?
Thank you for the question. I would answer that by saying we'd like to see the agreement extended beyond that 2025 date. And that is, again, that all costs associated with the operation, monitoring, and maintenance and additional modifications be covered by Saint-Gobain. Since the time of that agreement, too, the standards of July 2020 have gone into effect. There's certainly a chance before 2025 that the standards will change again. And I go back to my conclusion in that the customers of the Merrimack Village Water District cannot be placed in a position to pay for a private industry's pollution. Thank you.
If I could follow up.
You may.
If you get what you want, which is to change the terms of the settlement, doesn't Saint-Gobain have a right to go back and say, no settlement, we're going to litigate whether we're liable for this damage and what percentage of the damage we're liable for?
I would say they would consider that.
And if
You
I
have
could,
another question?
that's acceptable to you to start the process over.
Well, certainly I would like it if they didn't. But so far, Merrimack has had difficulty controlling any actions of Saint-Gobain. So I can't focus too much on what they will or will not do. My focus is making sure that the taxpayers of Merrimack don't bear costs of private industry pollution.
Thank you.
Representative McLean.
Yeah, thank you, Mr. Chair. Thank you for taking my question. Just to kind of follow up a little bit on where Representative Birch was going, since there was this settlement and there was an agreement, if new information has come forward, why would you not pursue further redress in the courts? What is making you pursue a legislative solution as opposed to going back to the courts again?
Thank you. That's a good and very reasonable question. A few things. In recent headlines have once again highlighted the difficulty the town of Merrimack has had with negotiations with Saint-Gobain. It's unfortunate. However, those in the Citizens for Clean Water, former Speaker Hinch, and myself, and others who worked so diligently on this bill, including the co-sponsors, felt that this was the best avenue.
Representative Page.
Yes, I think, thank you for taking my question, Mr. Chair, and allowing me the opportunity, Mr. Chair. I think Representative McLean may have touched on part of my question, but I'm wondering if Representative Mooney could elaborate just a little bit more. Anything the extent to which things have changed since the town entered in the settlement agreement on March 28th, 2018 to now, in terms of things that were perhaps uncovered that would more damage, more things that weren't known at that time when you entered the settlement agreement or could not have known at that time?
Thank you for that. That's a very good question as well. And I would refer you to that section RSA 485:16-E. It's cited in my testimony under the standards section. There will be individuals testifying after me who worked on that as those went into effect. Those standards of maximum contaminant levels, those standards went into effect July 23rd, 2020. And so they could certainly get into the details of that. I believe another part of your question was with regards to those who made the agreement. And the commissioners of the Merrimack Village Water District are elected. And so those that entered the agreement are not there at this time. It's a new group of commissioners.
Are there any other questions for Representative Moon? If I could just inquire, this is sort of a follow-up to the prior questions, and that is, there is in place an agreement, and I guess the question that I have is, do you have any reason to believe that that's not an enforceable agreement?
Thank you for that. I think in light of what's come about since 2018, in light of Saint-Gobain not being cooperative, and not just water, but now it's air filtrations and so forth, I think it's justifiable to say that a bill of this nature would be an appropriate avenue in this instance to look out for the best interest of the Merrimack citizen and taxpayer.
Any other questions, Representative? Okay, thank you very much for your testimony today.
Thank you.
We have, just for the committee's benefit, I'd note that 145 people signed up in support, 3 people signed up in opposition, and 2 people signed up as neutral. And we do have 12 people to testify today. And one of those people who did sign up to testify is Senator Gary Daniels, if he's available. Yes. I think you may be muted, Senator.
Yes, I was. Thank you, Mr. Chairman. Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Gary Daniels, and I am the state senator for District 11, encompassing the towns of Amherst, Merrimack, Milford, and Wilton. I appear before you today in support of and co-sponsor of House Bill 478. Let me start by saying that I'm a big advocate for businesses, because businesses are the vehicle to produce jobs and make prosperity possible for all New Hampshire citizens. But while I advocate for businesses, I do expect that those businesses will operate in a proper and responsible way, including the treatment of their employees and taking the initiative to ensure that no harm is done to the environment in the production of the products they make or the services they offer. I support this bill because my constituents in Merrimack have suffered harm from contaminants created by Saint-Gobain in the manufacturing of its products. And secondly, because the company has not fully mitigated nor in a timely manner responsibly addressed the pollution it has created and the harm it has done to the Merrimack community. Because of the inaction by Saint-Gobain, including its rebuff of the Merrimack Town Council in upholding its responsibilities, I feel that it therefore becomes necessary for this legislature to hold Saint-Gobain accountable for rectification of the damage it has brought upon the Merrimack community. And I don't do this lightly, but I have seen the frustration as the town council works to find resolution to this. And I have seen the stalling that has gone on behalf of the company in doing the responsible thing and upholding its responsible part of the cleanup. So I therefore respectfully ask that the committee vote ought to pass on House Bill 478. Thank you, Mr. Chairman.
Thank you for your testimony. Is there any questions for the senator? Seeing none, thank you again.
Thank you.
There is another sponsor who signed up, and that is Representative Rosemary Rum.
Good afternoon. Can everyone hear me?
Again,
Great. Thank you very much. For the record, my name is Representative Rosemary Rung, and I represent Merrimack, which is in Hillsborough County 21. I come before you in support of HB 478, and I bring many perspectives to this discussion. First, I am a 38-year resident of Merrimack and also a 38-year customer of the Merrimack Village Water District. I've served on the Resources Committee, which hears many water-related and PFAS-related bills, and I currently chair the HB 737 Commission to study the environmental and health impacts of PFAS. As you know from reading the bill, Saint-Gobain Performance Plastics Merrimack operation has caused PFAS contamination of our groundwater which serves as the sole source of MVD's water supply. This contamination is the largest industrial contamination in the history of New Hampshire, impacting not only Merrimack, but many surrounding communities. The level of PFAS contamination exceeds not only the EPA advisory limits, but also the New Hampshire maximum contaminant levels. When this contamination was first discovered in 2016, MVD commissioners scrambled to get a filtration plant built and reached a short-term settlement with Saint-Gobain to provide financial resources to do so. We have since learned, since that settlement, that the financial resources necessary far exceeds what was initially agreed upon. Studies conducted since the settlement, particularly a Minnesota study on the effects of PFAS on infants, shows a causal relationship so serious that it led the New Hampshire Department of Environmental Services to recommend far stricter standards than what was initially proposed for the maximum contaminant levels. So the responsibility of providing safe drinking water has grown significantly. Thus, the question before us is who holds this responsibility? Obviously, Saint-Gobain. Their chemicals leave their plant and enter our groundwater, and they should bear the responsibility and cost of removing them. But who should hold them to this responsibility? I contend that it is the state of New Hampshire. After all, it is the state that has entered into statute maximum contaminant levels, and that was just done a year or two ago. And it is the state that regulates and enforces these standards on municipal water systems. The state should have the responsibility to hold Saint-Gobain responsible for removing their chemicals from our public drinking water for as long as those chemicals risk the health of our citizens. And this is why I recommend to the Judiciary Committee an ought to pass motion on HB 478. Thank you, and I would be happy to answer any questions.
Representative Birch.
Thank you, Mr. Chairman, and thank you, Representative. I want to go back to your statement where you ask and answer the question. The question before us is who holds this responsibility? Obviously, Saint-Gobain. From a legal point of view, that is based solely upon the agreement that now you suggest be ripped up. Are you also comfortable with Saint-Gobain having the right to go back and litigate what level of liability they should have, whether it's 100%, 50%, 75%? And secondly, the amounts of money that Saint-Gobain has spent in detrimental reliance on this agreement, which is probably right now in the millions, is that money going to be refunded at this point to Saint-Gobain by Merrimack?
Well, let me kind of put things in perspective about Saint-Gobain. In 2020, they had a net income of $1.75 billion. So when we talk about any money they've spent in Merrimack, I think we have to put it in context to the overall income that the company provides. But I look at this bill in a way kind of separate from the settlement. The settlement is in place. It was negotiated in good faith by both parties, and it has an expiration date. But if I could use an analogy, Representative Birch, to help you understand the situation, imagine that you had a next door neighbor, okay? Maybe it was a convenience store. Maybe it was you know, grocery store, whatever, and their trash continued to blow on your property, and you reached an agreement with them that for 5 years they have to clean up and they have to absorb the expense of cleaning up that trash. Now the 5 years is over, but unfortunately their trash is, they have not remediated that, and the trash is still blowing on your property. Who's responsible for enforcing that? Do you have to go back to court to have a settlement? But shouldn't the town or the municipality who has litter ordinances be the responsible party for cleaning up that litter, for forcing your neighbor to clean up that litter? Why should you be the enforcer of laws and ordinances? That's the responsibility of government. That is why I believe that it's very appropriate for the state and for the general court to force Saint-Gobain to take responsibility for its contamination and the cost of it therein. I hope I answered your question.
I don't think you answered either part of the question.
Oh.
That's okay. I get where you come from.
Yeah, the settlement agreement is, you know, it's an agreement. It's isolated. It has a begin date. It has an end date. There are costs that have been covered by Saint-Gobain. But even with or without that settlement agreement, Saint-Gobain is contaminating groundwater. They're violating the state's maximum contaminant levels. So who should enforce that? Who should force them to comply?
Thank you. Representative McLean.
Yeah, thank you, Mr. Chair, and thank you for taking my question. So with respect to the original settlement, a lot of information has come to light which would make you want to revisit that. And I can completely understand that. I guess the concern I have is with the legislative solution. I think what this sort of does is maybe sets up a situation where everybody who is polluting in the future, we could maybe have 200 or 100 cases where we have to have this, as opposed to allowing them to go through the courts. So what makes, and I don't think you would be advocating that every case of a polluter would have to come to the legislature. So what makes this so special that in this particular case, it has to fall outside of the courts and you have to pursue that legislative remedy?
Well, thank you very much for your question. I think the big game changer in my mind is the establishment by the state of New Hampshire of maximum contaminant levels for 4 PFAS chemicals. We now have that in statute, these drinking water standards. And those are enforceable by DES. And so I look at it that DES or the state should ensure the enforceability of those standards. Now, those standards in Merrimack are being violated because of the direct contamination by Saint-Gobain. So it's my opinion that the state should compel Saint-Gobain to absorb the cost of removing those contaminants to the level where the water meets the MCL requirement.
Want to follow up?
Yeah, just so if as a result of the new standards, and thank you for taking my follow-up question, but if as a result of the new standards, we find 10 additional polluters, would all 10 of those polluters then have to be brought before the general court, or should they have to go through the courts? What is your thought on that?
Well, my thought is I would like to see DES enforce these standards. I mean, it's unfortunate that the Merrimack Village District had to enter into a settlement agreement with Saint-Gobain in the first place. It should be the state's responsibility. We have a Department of Environmental Standards. It should be their responsibility to compel and force polluters to clean up their contamination. I think had that been done when DES first issued a consent decree against Saint-Gobain, we would have never been in this position. But as I said in my testimony, at that time, people in Merrimack were frantic. we were drinking water, we were making formula, we were showering in water that exceeded even the Environmental Protection Agency's health advisory. So it was a desperate time to do what we could to, as soon as we could, to get that water cleaned up. At that time, I don't think we had the information that we had now. I think if we did, that settlement agreement would have lasted as long as it takes to get the water cleaned up. But it was only issued for 5 years. And during that time, more information about the dangers of PFAS have come to light. But you know, it's my opinion that the state of New Hampshire bears the responsibility of forcing companies to comply with their regulatory requirements, not municipalities and not water districts.
Okay. Thank you very much.
Thank you. Thank you for the question.
Representative Sylvia.
Thank you, Mr. Chairman, and thank you for taking my question, Representative. Just to get a little more background and fill in the context, could you, 2 parts, could you tell me about when Saint-Gobain came to Merrimack? And then at the time that it was coming, was it encouraged by the town of Merrimack, or was it protested?
Oh, I think Merrimack, thank you very much for the question, by the way. I think Merrimack welcomes all businesses. You know, we've got major employers in town, Fidelity Investments, Anheuser-Busch has a brewery in Merrimack. We have wonderful restaurants. I invite all of you to come and enjoy everything that Merrimack has to offer. Saint-Gobain, I don't exactly remember the dates, and I'm sorry I don't have that information with me. But they came to Merrimack. They had bought a facility that had been previously a manufacturer of GE jet engines. And when they came into Merrimack, they were actually a company called ChemFab, which had operations in Bennington, Vermont, and Hoosick Falls, New York. And they came to Merrimack, and then Saint-Gobain bought ChemFab and made it part of their performance plastics division. We did not know at that time that their air emissions contained such hazardous chemicals. In fact, at that time, I don't think even scientists knew the hazards of PFAS to the extent that they know them now. And they weren't regulated. Those PFAS chemicals, and they're still not really regulated on a federal level, although I do believe that's coming. So it was really up to the states to regulate them. But we welcomed Saint-Gobain, but you know, no matter how, you know, how many employees they hire or employ or things they do, they're contaminating our drinking water, and they're doing it to this day. I don't know. I forget if I answered both those questions. I'm sorry about that.
The other part was just about when they came, but that's all right. If I could follow up, Mr. Chairman, briefly.
You may follow up.
I assume that over the time that Saint-Gobain has been there, they have certainly contributed largely to the community. The pay of workers are probably housed locally there. Would that be the case?
Oh, I'm sure there are Saint-Gobain employees here. And, you know, I mean, I think, I mean, anything they could do, they've poisoned our water. PFAS levels in our water cause infant low birth weight, premature birth weight. They've been linked to several cancers. New Hampshire has the highest incidence of pediatric cancer. We've learned a lot about the health impacts of PFAS from what's going on at the Pease Trade Port and a history of firefighting foams. So I'm not willing to settle for poisoned drinking water just to have a good employer in town. I think any employer that's going to pollute a basic necessity of life is not a good employer, no matter how many people they employ, no matter how many salaries they pay or community donations they make. Safe drinking water has to be a fundamentally protected resource for our communities.
Thank you.
Thank you.
Representative Birch.
Thank you, Mr. Chair. Thank you, Representative Rung. I just had a question to clarify something in my own mind. You refer throughout this agreement as a short-term settlement. And I'm puzzled, so perhaps you can explain, is the settlement itself limited in time, or just the obligation of Saint-Gobain to do certain things are limited to 5 years?
Well, what is, oh, thank you for the question. I'm getting some feedback. Can you hear me okay?
Yes.
Okay, must be on my end. The settlement agreement allows for Saint-Gobain to cover some of the operating and maintenance expenses for 5 years. That's the gist of it. After that, the burden of continuing the cost of those filtration operations lies on Merrimack Village District. And we're contesting that because PFAS is a forever chemical, because it is still present in the water coming into those wells, that that even after that settlement agreement expires, Saint-Gobain should bear the responsibility of cleaning up that water so that it meets the state's mandated maximum contaminant levels.
You could, if I may follow up.
Yeah.
You confuse me in your language about when the settlement agreement expires. That's not the same, I believe, as the obligation of Saint-Gobain to remediate expires. The agreement, the settlement agreement is in perpetuity, is it not?
You know, I have to go back and check, and unfortunately, I'm not in my office. I have some. I'm on some personal business, so I don't have all my files with me. But my understanding, and there's probably others that are going to testify that will have answers to this question, is that Saint-Gobain is not taking necessarily the responsibility for remediation. They're just contributing monies. And even the monies they're contributing are finite. It's not, it's a set amount. They're not covering the exact cost. They're giving so much money, and those monies go away after 5 years.
Thank you.
Representative Page.
Thank you, Mr. Chair, and thank you, Representative Rung, for taking my question. If you're not the right person for this question, then you can defer me to who might be in the testimony later. I want to go back to the moment in time when the settlement agreement was made. You described kind of a chaotic situation in Merrimack, given the sort of desperation, I think you said. And I know you weren't part of the settlement agreement, and I was reading a testimony from someone who was in the water district that sent a letter that said, on advice of town council, he's not going to testify today. But perhaps you can tell us a little bit. You said the PFAS science has changed since then, the knowledge. I'm wondering if there's anything that you know of that at that time Saint-Gobain knew about PFAS that you didn't know, that would have been material to the length of their obligation. And you may, I don't expect you would know this, but maybe you do, or can point us to someone that might. Sort of material information about the nature of PFAS that might change sort of the horizon for our obligation.
Thank you very much for that question, Representative. One of the things that I became aware of after the settlement agreement was reached is that the town of Hoosick Falls, New York, where Saint-Gobain had also contaminated with PFAS, they had reached an agreement with Hoosick Falls that provides for long-term remediation. I think it's in perpetuity, but don't quote me on that. And they're covering the cost. It's not like a set amount. So I felt they knew when they went into that settlement agreement that the cost of remediation is much, much higher. I think, and this is just my opinion, but I felt that they took advantage of our desperation to get clean drinking water. Because you have to imagine wells 4 and 5 are the largest producers of the Merrimack Village District. So this was a big concern for people in Merrimack. Had we known at that time that Saint-Gobain was already aware of and had already entered into agreement with the town in New York and had provided much more considerable support for their water cleanup and taken much more responsibility, I think our settlement would have looked a lot different.
Are there any other questions for Representative Rowe? Seeing none, thank you for your testimony today.
Thank you very much. I appreciate your input.
We have Robert Healy. This is Representative Healy.
It's actually Robert Healy, Representative Robert Healy.
Yep.
Hey, and thank you, Mr. Chairman, and thank you, members of the Judiciary Committee. I am Representative Bob Healy of Merrimack, and I'm speaking as a co-sponsor and in support of House Bill 478. This was a bill that the late Speaker Dick Hinch had on his list as a priority for the citizens of Merrimack. Merrimack and the surrounding communities, including Bedford, have been dealing with the PFAS contamination issues in the areas surrounding the St. Gobain Performance Plastic Facility since 2016. The contamination has been found in our air, soil, groundwater, and drinking water that is supplied by the Merrimack Village District, better known as the MVD. We have had to deal with the wells belonging to the MVD being shut down due to the high PFAS contamination rates. This in turn causes issues, especially in the summer when the demand is high. The MVD has had to purchase water from other sources to meet the demand, which then raises the cost of the water for all of our customers. While St. Gobain agreed to pay to filter the contaminated wells, the price to filter the water from the MVD wells was over $5 million, of which St. Gobain paid just under $4 million, leaving the taxpayers on the hook for the remainder. Also, St. Gobain only agreed to pay for a portion of the future operation of maintenance costs of the water treatment system, which is limited to the first 5 years of the operation. There's a reason the PFAS are called forever chemicals. PFAS does not degrade easily and only under very high temperatures, about 1825 degrees Fahrenheit. Unless actively remedied, PFAS will continue to contaminate our soil and water for years into our future, our children's future, and grandchildren's future, as well as our great-grandchildren's future. As stated in the text of the bill, the PFOA concentration at wells 4 and 5 has measured in excess of 100 parts per trillion. The half-life of PFOA in water is greater than 95 years. The decrease of the current PFOA concentration will require approximately 3 lives or 300 years to reduce from 100 to 50, which still exceeds the current MCLs of 12 parts per trillion. Agreeing to pay only a portion of the future operation and maintenance costs for only 5 years, the equivalent of a blink of an eye when you look at it from the perspective of how long the contamination will last. You may ask yourself, it's important, then shouldn't the customers and ratepayers just pay for it? The customers of Merrimack Village District didn't pollute the soil and the water. Per New Hampshire DES, St. Gobain is responsible. That being the case, requiring St. Gobain to pay for the filtration, the operation, and the maintenance is fair and common sense solution to take this burden off the customers and the citizens located in Merrimack and Bedford, and to resolve the public health hazard. To refresh your memories, researchers finding these forever chemicals are causing more and more harm to people. They have found potential adverse health effects associated with PFAS exposure, including liver damage, thyroid disease, decreased fertility, high cholesterol, obesity, hormone suppressor, and cancer. Again, I speak in favor of House Bill 478 today.
Thank you very much for the testimony. Are there any questions for Representative Healy? Seeing none, thank you very much.
Thank you.
The next person will be Bill Boyd. Well, Mr. Boyd, you need to unmute. Okay, you're on.
Hi, can you hear me?
You can.
I apologize, Mr. Chairman. Thank you very much for hearing me and through you and to the ranking member and the members of your committee. My name is Bill Boyd. I'm the Vice Chairman of the Merrimack Town Council, and I'm here today on behalf of the Town Council to speak in support of House Bill 478. The Town Council has sent in a letter to you previously expressing our support. My testimony here today is seeking to amplify that particular letter that was sent to you under separate cover. There are three specific points that I would like to, or two specific topics that I'd like to get into. First off is the settlement agreement between Saint-Gobain and MVD for as it relates to wells 4 and 5, which is an agreement that occurred in February 2018. On April 1st, DES had issued a letter to Saint-Gobain mandating that they pay for ongoing operation and maintenance of PFAS treatment at all of MVD's public supply wells. And at that particular point, DES and the AG's office chose not to issue a consent decree against Saint-Gobain as it relates to that contamination. MVD, as a consequence, was required to negotiate its own settlement agreement with Saint-Gobain without the assistance of DES or AG. That settlement agreement requires Saint-Gobain to pay for a portion of PFAS treatment at MVD wells 4 and 5, but it only requires Saint-Gobain to pay for the the GAC, the media, the filter media changeouts. That's only paid for 5 years, and it's important to note that it's only 5 years that they're paying for that particular maintenance piece. Consequently, the refusal of DES to issue a consent decree on MVD's behalf is the inconsistency that House Bill HB 478 is seeking to correct. Secondly, the state agreement consent decree negotiated by the state with Saint-Gobain in March of 2018, as it relates to the affected private wells, which were excluded from the original consent order. One of the things that they developed was a groundwater management zone, otherwise known as a GMZ, and it delineated both parties. And it also included areas not just Merrimack, but it also included the communities of Manchester, Litchfield, and Bedford. Two GMZ boundaries were delineated, one a preliminary inner boundary and an outer boundary, which limited the extent of Saint-Gobain's responsibility. Saint-Gobain is required to mitigate all PFAS contaminated private wells within the pre-GMC area. Please keep in mind, what's not mentioned is that MVD wells 4 and 5 are inside that pre-GMC innermost boundary, similar to the private wells required to be regulated. One of the things that private well consent decree did was to provide bottled water with private wells to people with private wells within that pre-GMZ. They were able to pay for an extension and connection to private wells for available public water supplies. If I know you folks have been paying attention, Litchfield benefited from connections with Pennachuck Water Supply. And then part of the other thing was to pay for future private wells to be determined the level of the contamination and to determine whether or not is a point of entry treatment, a home filter is going to be beneficial, or whether or not they need to be hooked up to a public water supply. Excuse me. So at the end of the day, what all of this means is that Saint-Gobain is obligated, at least from my perspective, is obligated to pay for the point of entry treatment, including the change out of the filter media. Because DES chose not to issue a consent order regarding the contaminations, that means after 5 years, those change outs are now going to be the responsibility of the private well owners and MVD, the ratepayers to MVD for wells 4 and 5. MVD customers are going to be paying to treat these wells for a very long period of time. So why should MVD customers be required to pay to treat something that is the responsibility of someone else? And in this case, allegedly Saint-Gobain. As I stated initially, MVD wells 4 and 5, the subject of HB 478, are located within the pre-GMZ boundary, just like the private wells are. Again, the same also applies to them. Why should they be paying for their own treatment? At the end of the day, from my perspective, a regulatory flaw exists within the laws whereby DS and the AG's office really did not or could not act on behalf of MVD customers by being able to negotiate a consent decree for wells 4 and 5. So subsequently, this is an opportunity to correct that regulatory flaw. I thank the chairman and the committee members for the opportunity to present, and I'm happy to answer any questions.
Thank you, Mr. Boyd. Representative Smith?
Thank you, Mr. Chairman. Mr. Boyd, I have to begin by saying that I am in awe of the knowledge and the degree that you and your colleagues go into this issue. And so forgive me for asking a very naive question.
That's okay, Representative Smith.
Thank you very much. That makes me feel better. I have one question, but they're kind of two parts to it. One, again and again and again in New Hampshire, we have cities and towns expressing annoyance at the state for getting involved in what cities and towns see as their prerogative to make decisions about what happens in their communities. And here I see quite the opposite, that you really want the state to get in and kind of take over, directing St. Gobain about what they have to do. And the other side of that is I hear you saying that the department refused to take steps that you think might have helped resolve the issue. And of course, while we're the legislative branch, we really are pretty closely related to the executive branch. And all of that comes together for why don't you see the resolution as going to the third branch, to the judicial branch, to resolve these differences? Does that make any sense to you, Mr. Boyd?
Absolutely, and I made 3 quick notes. So Representative says, thank you so much for the question. I do appreciate it. The state, if the state can't get involved because they don't have the tools to get involved, then that they're only playing by the rules by what is handed down to them legislatively or what gets communicated through them. And again, I'm not familiar with how things operate up in Concord, but the JL Cars committee is obviously responsible for any legislation that's signed into law and is promulgated forward. It's them that creates the rules for those particular laws, and DES can only operate within those particular parameters. So that's number. From where I sit, I'm not sure it's a refusal, which is why I said the proposed legislation is to correct the flaw. It's the ability to be able to have that particular impact. Number 2, I am, just so you know, as a town council, I am very much a local control kind of person. I want my town to be able to self-determine and decide what are the things that we need to be resolving to maintain and promote our quality of life here in Merrimack. This is why the town of Merrimack filed for injunctive relief in Hillsborough Superior Court. The Department of Environmental Services, ironically, had filed suit earlier in that particular day, but we chose to take the bull by the horns because the facts and the data were certainly on our side to seek injunctive relief at the court level. If we have the ability to issue building permits, talking in general, and if somebody doesn't follow that building permit, we have the ability to enforce that person do what they need to do to subscribe to that same building permit. It's the same concept with San Gobain. If we tell San Gobain to cease and desist because they haven't met the rules of what's going on in town and they ignore us, we have to ask the state, say, can you join us, because we're not getting the relief, we're not getting the remedy from this particular individual in our community who's not choosing to listen to us and is not choosing to play by the rules. So at the end of the day, as it relates to this particular bill, in light of your question, we're just trying to make the rules fair for everybody.
Thank you.
Does that make sense, Representative?
Thank you very much for your response.
I appreciate it. Thank you.
Any other questions for Mr. Boyd? Representative Langley.
Thank you, Mr. Chair, for taking my question, and thank you, Mr. Boyd. I have some anxiety about asking this question, but I need to put it out there.
No, go right
Running,
ahead.
running between the towns of Merrimack and Londonderry is, no, yes, Londonderry and Litchfield and Londonderry,
Litchfield.
excuse me, is the Merrimack River.
Correct.
And I'm wondering, has that been tested and for runoff from some of these wells, or just the groundwater into the river from the two sites that have already been identified?
I appreciate your question. Thank you very much. Currently on San Gobain site, they have 2 testing wells. Both of those testing wells continue to exceed the limits of what the state has determined to be an acceptable level of PFAS. It's the last number that I saw, and I'm probably going to cause my assistant DBW director a little bit of indigestion, but I think it was 1,500 to 2,000 parts per trillion were found in those particular testing wells. One of the things that we've asked, and as you're familiar with our MS4 stormwater permit, that's one of the things that the town is concerned that there may be additional costs as a result of that particular cleanup. So circling, based on the evidence that has been communicated, the probability of PFAS running off of San Gobain's property into testing wells, into groundwater, and then, percolating up and moving south into the Merrimack River is very prevalent. It is happening. To what levels? I haven't seen a report on PFAS levels in the Merrimack River for a couple of years, but I know when the onset of this problem occurred back in 2016, they were identifying levels of PFAS in the Merrimack River.
Thank you, Mr. Boyd.
You're welcome.
Any other questions for Mr. Boyd? Yes, Representative Di Lorenzo.
Thank you, Mr. Chair, and thank you, Mr. Boyd, for taking my question. Seems like there are a lot of layers here, and it's really hard to figure out, who's going to carry the ball on this. And my thought is, has the town contacted the EPA, the federal EPA, about this issue?
The short answer is no.
And may I follow up?
You may.
Is there a reason why the town has not contacted the EPA, since it sounds as if you couldn't get satisfaction from DES or the Attorney General's office?
I think if I were, and I'm not trying to be coy, Representative, that what you're asking could constitute being part of the town's legal strategy. And I certainly would not want to offer a statement that may compromise any legal strategies that the town may have.
Thank you.
Yeah, if I could ask, Mr. Boyd, were you involved in the negotiation of the contract with the 5-year limitation?
No, I was not. That MVD is a separate utility from the town of Merrimack, and it was under their auspice that the contract was negotiated.
Thank you.
You're welcome.
Any other questions? Seeing none, again, thank you for your testimony today.
Mr. Chairman, to the committee, thank you so much. Please be well, be safe.
We have Donald Provencher.
Hello?
Yes, we can hear you.
Great, thank you. I just have a quick statement to present. My name is Donald Provencher. I am a professional civil engineer with Bachelor in Civil Engineering from UNH, a Master in Geoenvironmental Engineering from UMass Lowell. I'm also president and founder of Provencher Engineering, which specializes in water supply engineering for 20 years. With that experience, I ran for and was elected to the Board of Commissioners at MBD in March of 2018, and I've been chair for that commission for the last 2 years. I've become intimately familiar with the history of MBD's involvement with St. Gobain and the settlement agreement at Wells 4 and 5. However, despite that, I am here today to explain that MBD will have a notable absence in today's participation, and that's not due to a lack of interest, but is due to advice from our legal counsel to not proceed or provide testimony today in an effort to avoid potential legal retribution by Saint-Gobain for doing so. I do trust that this committee will listen carefully and consider all testimony presented from all parties and in future deliberations on this bill. But I will remain engaged in this Zoom meeting and available to provide any facts or clarification needed today or later pursuant to next week's executive session deliberations. And I've submitted this written testimony or written statement. So you do have my contact information if you have any questions. I sent that to the House Judiciary Committee at legislativestate.nh.us. So if there are any questions, I am available. I do need to make sure that I stay to just the facts as I know them to exist. And I just wanted to make it clear that I'm here for that purpose. Thank you.
Are there any questions for Mr. Prevention? Yes, Representative Wolper.
Yeah, Mr. Prevention, could you tell me who you're talking about? You said you chairs a commission.
I wasn't sure if I heard that all quite clearly.
I think Representative Wolper was asking what organization specifically that you are associated with.
Yes, so I am the chair of the Board of Commissioners of the Merrimack Village District. That's MVD. MVD is the one who negotiated the settlement agreement with Saint-Gobain, and that was prior to my involvement with the board. Again, I was elected in March of 2018. And a matter of fact, the night that I was elected was the night that the settlement agreement was announced by the previous board members at the annual meeting of the MVD.
Yes, Representative Page.
Thank you, Mr. Chairman. I'm going to sound like a broken horse or whatever, but Mr. Prevention, to the extent you can answer this question, is there anything that you know now that you know Saint-Gobain knew that the folks who entered the settlement agreement on the 2018 date would have changed their mind had they known what Saint-Gobain knew? So, did you follow that? And if you can't answer it for whatever reason, but I apologize.
Yes, I do understand, Representative Page. Thanks for that question. I think the best answer I can provide is that I can relay a site visit that MVD attended in Hoosick Falls, knowing that Hoosick Falls was building a granular activated carbon treatment plant, and they were involved in a similar contamination situation in Hoosick Falls, New York. Some members of MVD staff, as well as our consulting engineers, made a visit over to Hoosick Falls to speak with the operators of that treatment plant. There was a treatment plant built out there for the same contamination as we are experiencing. So we wanted to get some insight. And when we were at that visit, we asked the representatives, the operators there that were in the treatment plant, some questions about what the cost is and how frequently the media is changed. And their answer to us was that they didn't have a lot of information specifically because they actually didn't do the filter changeouts of the media. That was all done by Saint-Gobain and Saint-Gobain's staff. And everybody from MVD looked at each other in astonishment because nobody was aware that that was the case. So upon further questions, and subsequently we had this verified by our own legal staff at the time, we subsequently found out that Saint-Gobain had been changing out the media filters on their own cost as soon as the first breakthrough of the first PFAS compound came through the filters. And that astonished look on the face of some of the members of MVD who were present in part of that settlement agreement, that was a complete surprise to them. So I think that surprise that they are paying in Hoosick Falls for the change out of that carbon filter media, and have been paying for that since we have since found out, since that went online in 2016, is a material difference from what our settlement agreement provides with only 5 years of operation and maintenance. So that's one of the big unknowns that we didn't know at the time, apparently.
Thank you.
Representative Sylvia.
Thank you, Mr. Chairman, and thank you for taking my questions. Just one. Are all aspects of the settlement agreement public?
Yes, absolutely. That's all public information, and we can send that to you.
Thank you.
Are there any other questions for Mr. Provencher? I guess the question I have is sort of a follow-up to Representative Page's question. And that is, if you've entered into an agreement, you've entered into a settlement agreement with Saint-Gobain, and there are reasons why that agreement could be nullified. I think Representative Page was sort of getting there. If there was a mutual mistake or some type of fraud, and that might be a reason for doing that. And I'm presuming that that might be one reason why MVD is not being forthcoming, because they have their own legal strategy as to how they're handling that. And why wouldn't we, in considering this bill, wait to see if there is some legal challenge to the validity of the agreement as opposed to taking some type of legislative action?
I think the best way to answer that is to describe to you the outcome of a meeting that was held at the Merrimack Town Hall in November of 2019. At that time, the late Speaker Dick Hinch had requested a meeting. Upon my request, there was a bunch of questions that I had regarding the settlement agreement. And the late Speaker Hinch had called a meeting with the governor, the DES, and the Attorney General at the town hall in November of 2019. And at that meeting, there were representatives from the town council, the MVD was there, and some representatives from Merrimack were in attendance. The question was asked about why did DES not follow through on their April 1st, 2016 letter, which requested that Saint-Gobain provide treatment and pay for that treatment for all public water supplies affected, which was affecting MVD. And why did they not enforce that letter? And basically, we were told at that time that DES did not have authorization to enforce that letter because they cannot negotiate on behalf of a private entity. Well, MVD is still considered a public entity. And basically, under the provisions of RSA 485, we believe DES does have authority to enforce that April 1st letter. But at that meeting, we were essentially told by the DES that there's nothing more that DES is going to do for MVD in this matter, and that we were pretty much left on our own from that point forward. So that's kind of the answer to my question, basically.
Any other questions for Mr. Provencher? Seeing none, thank you for your testimony today.
Thank you.
We have David Creer.
There it is. Thank you all for having me here. My name is David Creer. I am Director of Public Policy for the Business and Industry Association of New Hampshire. I'm here to speak in opposition to this bill because it is bad public policy to alter these types of agreements after the fact. This sends a signal to businesses that New Hampshire is not a business-friendly place. And what's going to end up happening is that businesses will be less likely to cooperate in negotiations if they, feel that if the outcome of the negotiation doesn't go as far as, the townspeople wanted, well, they're just going to legislate a new negotiation or a new agreement with that business. So they'll be less likely to cooperate in those negotiations, and we'll end up, litigating cases fully, which will only delay any remediation for, towns in situations like this. Also, this will, because it's sending that signal of being a non-business friendly state, businesses will start to look elsewhere to either expand or move their business, which can have serious detrimental effects on our economy. Happy to answer any questions that you may have.
Are there any questions for Mr. Creer? Representative McLean.
Thank you, Mr. Chairman. Thank you for taking my question. So one of the things that was discussed is that they're getting a lot of feedback from DES. The DES felt that they did not have the authority to enforce elements of the agreement, if I understand that correctly. So would the BIA be open to going back, rather than having a specific carve out of the specific settlement, to look at, are there areas that are maybe murky that need to be clarified, and look at that? Is that something you'd be willing to look at?
In terms of the agreement, you mean going back and look at that?
In terms of, on a broader scale, just looking at those areas of the law where DES feels they're hamstrung and don't have the ability to act.
Oh, okay, I see. Well, without seeing any language, it'd be hard for me to take any specific position on a bill like that. BIA has a pretty extensive policy decision process where we, speak with our members, and we have committees and hold roundtables, and it's a pretty extensive process of making these policy decisions. So unfortunately, I wouldn't be able to, commit one way or another without seeing any specific language and running it through that process.
Thank you.
Any other questions for Mr. Creer? Seeing none, thank you for your testimony today.
Thank you very much.
Nancy Murphy.
You see her?
Yep.
Oh, she's under on.
Hello.
Hello.
Can you hear? Oh, great. Thank you. Good afternoon, Mr. Chairman and honorable committee members. My name is Nancy Murphy, and I'm a resident of Merrimack. I'm here to voice my support for HB 478 and to respectfully request your support as well. This bill is not only important to those of us in the town of Merrimack, served by our local municipal water supply system, the Merrimack Village District, but to MVD ratepayers in Bedford as well. To better understand why there's a need for a legislative solution, it's important to know a bit of the history that has made this bill necessary. As you know, in early 2016, the Merrimack community, with a population of around 27,000 residents, was first informed that our public drinking water was contaminated by PFAS. Many private wells were found to be contaminated as well. DES identified Saint-Gobain as the polluter. Manufacturing processes that led to PFAS releases via air deposition and other PFAS discharges from the Saint-Gobain facility resulted in regional groundwater contamination. Former DES Assistant Commissioner Clark Frizey shared that the extent of this southern New Hampshire area contamination made it the largest environmental industrial disaster in New Hampshire's history. Though all 6 of our wells are contaminated, MVD public wells 4 and 5 are located closest to the Saint-Gobain facility, and they were shut down as the PFOA levels alone exceeded the federal health advisory for PFOA and PFOS. These wells are situated within the preliminary groundwater management zone agreed to by Saint-Gobain and DES in a March 2018 consent decree. MVD wells 4 and 5 required PFAS filtration or treatment before they could be put back online. As science-based knowledge relative to the toxicity of PFAS and potential risk from exposure to these chemicals grew, the EPA lowered its health advisory to 70 parts per trillion. And on July 23rd, 2020, HB 1264 was enacted and set health-based enforceable drinking water standards on MCLs for 4 PFAS. Though not responsible for the PFAS contamination of wells 4 and 5, the MVD will be required to comply with the 2020 drinking water MCLs that have been signed into law and provide safe, regulation compliant drinking water to all MVD customers, some of whom are actually former private contaminated well owners who have now been connected to the MVD as part of the DES Saint-Gobain consent decree. Given the highest concentrations of PFAS in wells 4 and 5 and the biopersistence of PFAS, it will take hundreds of years until the PFOA concentration at wells 4 and 5 will be reduced to the current 12 parts per trillion MCL. I'd like to address the issue of who should be holding Saint-Gobain accountable, and I think this is part of the challenge and what has necessitated HB 478. A letter dated April 1st, 2016, with the subject heading regarding PFOA matters in Southern New Hampshire, was sent by DES Commissioner Thomas Burak to Mr. Edward Canning, Saint-Gobain's Director of Environment, Health, and Safety at his New York address. This 5-page letter references, quote, a number of critical steps that need to be taken immediately to address the threats to public health and the environment posed by PFC contamination, and provided a 3-page list documenting actions that needed to be taken by Saint-Gobain. DES made it clear in that letter that it had an expectation of prompt cooperation by Saint-Gobain. In addition to site remediation, on page 3, the section most important and relevant to this legislation appears, as it cites the steps that Saint-Gobain needs to take relative to public water supply treatment. It specifically lists the design, installation, operation, and monitoring of all water treatment systems necessary to effectively treat and remove PFC contamination from all affected water systems, and that Saint-Gobain will, quote, provide for the necessary long-term operation, maintenance, and monitoring of the installed treatment systems. Though DES had issued this April 1st, 2016 letter to Saint-Gobain, it did not, nor did the AG, take action to issue a consent order against Saint-Gobain regarding contamination of Merrimack Village District wells 4 and 5. The expectation that Saint-Gobain provide the aforementioned long-term operation, maintenance, and monitoring reference within the letter, though stated, was not enforced. That's what made it necessary for the MVD to negotiate its own settlement agreement with Saint-Gobain without DES or the Attorney General's assistance. And I just wanted to, I know a couple of comments came up about who was involved, and I think it should be noted that there was no community involvement. There was no input sought from community members who were aware and were concerned about this issue. That was an agreement that was made by a former group of elected officials to the MVD. It's interesting to note that a very similar scenario had played out with Saint-Gobain contaminating our MVD public drinking water well, had occurred in New York just 2 years prior. In 2014, Saint-Gobain and Honeywell International jointly contaminated municipal wells at the village of Hoosick Falls, New York, via air emissions. PFAS deposition and subsequent aerial groundwater contamination resulted, just as it did in Merrimack. Similar situation, same polluter. But what happened next is quite different. Our state's response was different, which led to the need for HB 478 now. In January 2016, New York's governor announced an emergency regulation to classify PFOA as a hazardous substance and the Saint-Gobain McCaffrey plant as a state Superfund site. New York's Department of Environmental Conservation, or DEC, issued an order of consent and administrative settlement, which was signed in June 2016, naming Saint-Gobain and Honeywell as respondents and mandating that Saint-Gobain there comply with what is being asked here within 478. DEC required that Saint-Gobain provide design, construction, and maintenance of PFAS filtration for the village there, and it was to be online by by December 2016. and to pay for the long-term operation, maintenance, and monitoring of those PFAS filters. This was all within months of us finding out about our contamination here. MPD, pardon?
We have much more.
Oh golly, just maybe another minute.
If you're, yeah, and if you're reading it, we can read your testimony. We're going to submit your testimony. What we really need to do is hear from you individually.
Yeah. Okay. I'll try to finish up. We understand here in Merrimack that we're not New York, but given the consent letter there and the commissioner's letter here, made the same expectations of the same polluter for doing the same thing to the public water supplies of their host towns, we would have hoped for a more similar state response and to have had a similar outcome. The challenge has been that DES has seemed to believe that they haven't had the ability to act as we would have hoped they would be able to. The concern is if DES doesn't have that authority, then I would certainly suggest that it needs it. That this is making their job difficult, as well as the experience of PFAS impacted citizens and communities here. I'm hoping that a legislative response will negate the need for further litigation. We're 5 years into this. As people that have spoken before me have suggested, this PFAS contamination is costing us more than just money, health impacts, and we're paying for contaminated water to come through our faucets, as well as trying to purchase filtration systems for ourselves, buying bottled water, etc. It's time to prioritize the protections of people above profits. Thank you for your time and attention, and I ask that you please consider voting OTP on HB 478. Thank you.
Are there questions for Ms. Murphy? Seeing none, thank you for your testimony today. And we have Keith Pratt.
Hello.
Hello.
Okay, thank you. You can hear me. Thank you for the opportunity to provide some information again. My name is Keith Pratt. I'm a professional engineer and president of Underwood Engineers. We have offices in Portsmouth and Concord. In fact, we're just a few blocks away from the house. We've been providing water and wastewater engineering in New Hampshire for about 40 years, and 14 of those have been in Merrimack. We're currently designing 6 treatment plants in New Hampshire, including the 3 PFAS facilities in Merrimack and a PFAS facility in Dover. Underwood was involved with the planning and design of all the documents related to the PFAS facilities in Merrimack. I personally was present many of the meetings between Saint-Gobain and Merrimack as the settlement agreement was being developed, primarily to provide tech support. I was requested to be here because of our understanding of the project, so I'm volunteering my time really to summarize the costs of the facility, including the O&M. So we were there and when PFAS was first reported at wells 4 and 5 in February 2016, and again, when the wells were shut down that spring. And by May of that year, within 3 months, we'd actually developed our first planning document to look at the costs. And within 16 months, we had a 30% PFAS treatment facility plant designed, which is actually what's in place today. But even though at that time, it was really an emerging issue with very little industry knowledge, it was that 30% design that became the basis of and actually is attached to the agreement that was executed in March of 18. And the cost opinions of that were used in that agreement in that report were thought to be that the facility would cost $4.4 million. In September, later that year, there was a meeting held at DES, the request to Saint-Gobain, with representatives from all parties, and the outcome of that meeting, that the costs were reduced, essentially because it was thought by Saint-Gobain and their experience at other facilities, I think Hoosick Falls primarily, that the costs being presented were too high. And further, during the settlement agreements, the negotiations, the Saint-Gobain had identified that of the portions of 4.1 that were related to PFAS was around 3.3 million, which is really about $1 million less than the estimated cost to complete the facility. And actually, now that the project is complete, the costs are for the capital and design phase and everything else has come in right around 4.9 million, which actually doesn't include some of the preliminary costs up to that date. We had also developed O&M costs in 2017. We estimated that the facility would cost about $215,000, of which about half was thought to be PFAS related, and which is what Saint-Gobain agreed to pay, only the PFAS related cost. And despite attempts to get more O&M during that time, the final agreement, has been noted earlier, that is that they'd only pay 5 years of the PFAS related costs, or just over just over $500,000. And at that time, we believed that the carbon, which is the media that removes the PFAS, would last 2 years. 3 years later, now that we have more experience, more knowledge, and new regulations, we actually believe that the media would be replaced every year, and probably closer to potentially every 6 months. We're also finding that the cost of the media is more expensive as well. These two things have really significantly impacted the costs, the O&M cost. We now believe MBD is facing PFAS-related O&M costs for wells 4 and 5 in the range of $160,000 to $450,000 per year, or 50 to 400% more than what we thought at the time of the settlement agreement. The wide range really still considers the many uncertainties we have with PFAS treatment as well. So over the next 20 years, we're projecting that Saint-Gobain's portion represents about 6 to 17% of what we now believe the actual PFAS O&M cost will be. The cost to MVD over 20 years, we're projecting to be between 2.6 or 8.5 million for operations. So after 4.5 years of the wells being offline, the good news is the facility is working. The plant went online 4 months ago and is currently producing water with no detection of PFAS. The bad news is the capital cost is significantly more than what was anticipated, and the operation costs are as well. So hopefully that helps just at least put some perspective on the magnitude of costs, and I'd be happy to answer any questions, and thank you.
Thank you very much for your testimony. Representative Chase.
Can you hear me all right?
We can hear you.
Excellent. It's about time. Thank you for taking my question. And if you're not the right one, maybe somebody can help me with this. So as I'm sitting here listening, and I'm very concerned about the water safety and what could happen in the future. Where there is this town, Hoosick Falls in New York, and there's been a site walk, and we're finding out all this information. Is there some type of an agreement that the Merrimack can look at that Hoosick Falls has with Saint-Gobain, and how long they're going to be helping them and changing these filters? And, you know, if there's already agreement and there was a little bit of concern that maybe they took advantage of Merrimack residents because of the heightened problem that first started when it was approached, can it just be reviewed and looked at, and maybe use some of the language or some of the follow through with, maybe, I'm assuming it's an insurance company who's paying this, and be able to put that into the Merrimack needs?
Did you get that?
Does that make sense?
Get that question, Mr. Pratt?
Yes, thank you for the question, and I understand, and I can't speak to the document itself, but I do know the document exists, and I do believe the Merrimack has a copy of that document. There is an agreement between Saint-Gobain and the parties associated with the Hoosick Falls, so that does exist.
Okay. I guess that's.
Are there any other questions for Mr. Pratt? Seeing none, thank you for your testimony today.
Thank you.
Okay, and there is we have 3 more people who pre-registered to testify, all testifying in support of the legislation. And the next person would be Laureen Allen.
Hi, can you hear me?
You can.
Well, thank you so much for hearing our plea. And I must say, I feel really bad that your heads are exploding with what we in Merrimack have been dealing with since 2016. I know this is complex. I know there's a lot of layers, and I do understand what you're trying to do here and your job in determining if you are the place to deal with this or it should be pursued privately. I hear that as I'm listening. So for the record, my name is Laureen Allen. I have been a resident of Merrimack since 1985. I am a co-founder of a citizen group that I never set out in life to do, but myself and other members of the community became very concerned in 2016 over something that pertains specifically to this bill, what we would expect to be happening and what we would expect to see moving forward given discovery of contamination of our public water and what we were actually seeing. So we have done a lot of work as a community. We have done a lot of advocacy, and we have taken on roles that we never thought we would. So this bill was brought about by a citizen initiative. The late Representative Hinch graciously and, beautifully tuned into this issue and met many occasions with our citizen group. We also invited town council members, commissioners of the MVD, public at large, elected officials, our state senators, even our federal delegation. So we've had community meeting and sit down after sit down. So the long and short of it is back in 2016, you've heard several people testifying, referring to this letter that DES set out, basically laying out their expectations of Saint-Gobain to make right the situation at wells 4 and 5. So we believe that was to be happening. And what happened in this process is there were supposed to be some temporary filters that were supposed to actually come to New Hampshire from Hoosick Falls, New York. This is what kind of got us involved with Hoosick Falls in the first place. And we're like, what's that about? Turns out Hoosick Falls shares a polluter with us. And Saint-Gobain had immediately installed a temporary filter system until they could install a permanent one, which they have done. And we were told that these filters were coming to Merrimack very shortly. And a month went by, 2 months went by, 6 months went by. In the meantime, what happened is we didn't know they were getting, their negotiation pushback with Hoosick Falls was getting a little tense. And I think what was going on there was kind of fueling the resolve on this end as Saint-Gobain, a multi-billion-dollar international corporation. If you just look them up and see how many dots they have on the map in New England and North America alone, it's immense. So I'm a business owner in New Hampshire, and I do understand liability is part of what we do have to consider, in every business, whether large or small like my own. So I do understand this on their point of view is about liability, control. And I firmly believe that in restricting this agreement and limiting it to the 5 years, they feel that, it's no acknowledgement of harm. They're doing it in good faith, and then boom, they can wash their hands of it. So their ultimate goal is not to be responsible for damages or medical claims or medical monitoring. Clearly, for years, these chemicals cause a havoc of health issues. They play out through the lifetime, decade after decade. And, if we were to be granted health monitoring or something like that. This is a can of worms here. We have 25,500 members in the Merrimack community who use MVD water. So let me step back for a second. And I don't know how many of you have driven up and down Daniel Webster Highway ever. So we have kind of Saint-Gobain in the northeast corner of Merrimack. Behind them is the Merrimack River. They're on Daniel Webster Highway. If we travel south on that road a bit, in between Saint-Gobain and wells 4 and 5, wells 4 and 5 are due south of Saint-Gobain. I don't have to be a hydrogeologist to know which way water flows. I've kayaked and canoed and understand rivers and brooks and all that stuff. So in between Saint-Gobain,
I don't want to cut you short, but I think we've got filled in, with all the other testimony we've had with regard to the pollution and the effect on the waters and those things. I think what we really need to address or focus on at this point in time is why the legislature should get involved at this time with what was a private contract in the past.
I'll give you my pitch. I gotcha. So 2 issues were raised. Somebody earlier in this hearing, one of your committee members raised the issue of shared responsibility. I thought that speech was very interesting because what he stated was very similar to what Saint-Gobain argued back in 2016, which is why the negotiations for MVD and Saint-Gobain went behind closed doors. They asked for a closed door mediation process. The public was not happy, none of us, the town council, the town members, because we no longer got to be privy to what was being decided that impacted us every day. So what happened is they went into that mediation process, or commissioners are no longer in office. They were members of the public. They were older gentlemen. At that point, they were being told nothing by the state or the federal government as to the qualities of these chemicals. They didn't really know anything. And they were assured that they could handle this. The state kind of backed out and left them to it. So it really isn't right. So at this point, the settlement agreement that they finally did after 2 years, one of the commissioners, when he retired, said to me, I feel really bad at this point because we know so much more, but we couldn't get anything else agreed to. We just couldn't. So there's been avenues looked at. Someone earlier talked about meeting with the governor, actually, the governor, the assistant attorney general, and DES meeting to look at what we have for recourse. We have asked, environmental attorneys as a citizens group. We took citizens initiative because this is the only avenue we have. We have no legal recourse whatsoever to look at this agreement. MVD cannot advocate. They cannot go to court and say, hey, we have more information now and we want this looked at. What you have suggested here are very good suggestions. And we as a community have looked at those venues for many, many years. And unfortunately, none of them are possible. EPA Region 1 is aware of our woes. We've met with them on several occasions. What they have stated to us is your state has the authority. We have, is it RSA for the Clean Water 485, I believe it is. That RSA that someone referred to, I don't have the number because it's similar to this one, gives them the authority. The state has the authority. So the assistant commissioner of DES, who has since retired, said to us in a community meeting when we posed that question to him, we said, EPA says you have the authority to do whatever we need and whatever it takes. He said, well, we technically do, but here in New Hampshire, we don't like to overstep. We have a good partnership and working relationship with businesses. I understand that. He said, we can get further that way by litigation and it's cheaper. I understand that also. I understand his point of view. He said, but we're not going to take action unless we're legislated to do so. That was a very, very clear statement that was made to our community on many, many occasions. So the long and short of it is, Forever Chemicals, the wells are just south of Saint-Gobain. The numbers have gone up. On-site numbers on Saint-Gobain, 69,500 parts per trillion PFOA alone in their groundwater, in their ground monitoring wells on their site, just north of 2 of our public wells. So after 5 years, we bear the cost of this as taxpayers and residents forever, and they're basically off the hook. So that's really why we're coming to you here. We really understand you're in a tough situation, but we truly do not have a reason legitimately to file for reasons to nullify. Maybe a citizen group could. I'm not really sure how to do that, but the MVD's hands are tied. Thank you.
Thank you very much. Are there questions from Ms. Allen? Seeing none, thank you for your testimony today. And again, we're down to the last 2 speakers. Wendy Thomas.
Okay, Mr. Chair and esteemed members of the Judiciary Committee, I am former State Representative Wendy Thomas from Merrimack, and I come before you in support of HB 478, which is a bill that enforces adequate and fair restitution from an industrial polluter towards those who have been adversely affected. There are 3 points of this bill that I'd specifically like to address. Point number 1. The history of the MVD Saint-Gobain settlement agreement for MVD Public Wells 4 and 5, which was signed in February of 2018. The MVD Saint-Gobain settlement agreement for MVD Wells 4 and 5 was signed by both parties in February 2018. It was based on a preliminary treatment design, a preliminary treatment plant construction, along with the operation and maintenance cost estimates developed in 2016 and 2017. That information is specific to the two parties and to MVD wells 4 and 5 only. The cost and other information used in that settlement agreement from 2016 to 2017 was subsequently found to be inaccurate and underestimated. MVD needed to enter into settlement negotiations with Saint-Gobain because NHDES failed to take action to compel Saint-Gobain to pay for all of the necessary long-term operation maintenance and monitoring of the installed treatment systems as demanded in the DES letter to Saint-Gobain on April 1st, 2016. Point number 2 that I'd like to address concerns that passing HB 478 will set a precedent that any settlement agreement can be changed by the legislature. The uniqueness of this agreement resulting from DES's failure to take enforcement action is unique to this case. This uniqueness has no bearing on any other settlement agreements and would therefore not set any precedent that the New Hampshire legislature can overturn any other settlement agreement brought forward. This bill, HB 478, was modeled after a similar bill, HB 494, which compelled the Coakley Landfill Group to work with the DES to reach a consent decree to design and implement certain groundwater remediations, associated costs, and to establish a timetable to implement remediation. If DES had taken appropriate enforcement action pursuant to the DES letter to Saint-Gobain on April 1st, 2016, and if DES would have compelled Saint-Gobain to pay for all of the necessary long-term operation, maintenance, and monitoring of the installed treatment systems as demanded in the letter, there would be no need for this legislative action. This bill is similar. MVD has exhausted all other reasonable avenues to seek the restitution demanded by DES in its April letter to Saint-Gobain. MVD has met with the governor, the AG, and DES and was incorrectly advised by DES that they had no authority to compel Saint-Gobain to pay for all of the necessary long-term operation, maintenance, and monitoring of the installed treatment systems because DES claimed it had no authority to negotiate on behalf of a village district. MVD participated in and paid their consultant, Underwood Engineers Incorporated, to update incorrect long-term operation and maintenance costs and negotiate with Saint-Gobain a second time to provide additional costs that should and would have been fully covered if DES had enforced its April 1st, 2016 letter. My last point, point 3, is that this bill, HB 478, will provide an avenue, like the Coakley landfill bill, to correct deficiencies by a responsible party and to require taking the necessary actions required by DES. Although this bill would currently help MVD, it is important to have it in place so that if or when another town or water supplier is harmed by contamination from a polluter, and that polluter is compelled to address and provide remedial activities by DES, but fails to do so, or if DES fails to take enforcement action in follow-up to a demand letter to a polluter for remedial action, that town or water supplier will have an avenue available to them, similar to HB 494 and HB 478, to compel the polluter to take remedial action through an act of legislation. For these reasons, I urge you all to support House Bill 478, which would require adequate and fair remedial action from an industrial polluter towards those who have been adversely affected. Please vote OTP for this bill. Thank you.
Thank you for your testimony. Representative Horton, do you have a question?
Actually, mostly I was just saying that as I mentioned earlier to you in the ranking member, I have to leave early at 3, so it's now 3:02. So that's why I'm leaving a few minutes. So I thank Representative Thomas and everybody else who took
Thank
the
you.
time to testify, and thank you. So just didn't feel like sneaking out on it without acknowledging that I'm leaving a little early, which I hate to do. Thanks.
Thank you. Are there any questions for former Representative Thomas? Seeing none, thank you for your testimony today. That concludes the list, unless there's somebody else who feels compelled to testify today. And I don't see any hands. So that will end our hearing on House Bill 478. I just want to apologize. I didn't think it was going to be an issue this afternoon with regard to time. Otherwise, I would have set a time limit at the beginning, but then I didn't feel like good in the middle of everything. So in any event, thank you for your patience today. We do have executive session on the 10th at 9 o'clock. Everybody should be prepared to be there because we do have a lot of bills. I think there's going to be 17 of them altogether that we need to act on one way or the other. So if you can't be there, please make arrangements to have a substitute there. Yeah, yes, you should let the appropriate people know in advance. So, in any event, I hope you all have a great weekend. Unless there's something else, any other issues you want to raise? Thank you so much.
Thank you.
Thank you, Mr. Chair.
Thank you, Mr. Chair.
Have a good
Thank you.
weekend, everyone.
Thank you, Mr. Chair.